Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder, this is a video conference per Bagley King requirements. All cameras must be kept on during the duration of the meeting. If you're unable to have your camera on, you must indicate a reason for non-appearance during the meeting. Please be aware of the surroundings behind you. All committee meetings will be recorded and posted to the State Bar's website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen, then select auto transcript. Thank you.
Thanks, Kim. Crystal, can we do a roll call, please?
Yes. Connolly?
Present.
Elseroff? Escobedo? Milrod?
Present.
Elikani? Babcock?
Present.
Blakemore?
Present.
Campbell? Galkin? Gonzalez?
Present.
Huang?
Here.
King?
Here.
Klein?
Here.
Mahoney?
Here.
Morales? Pryor?
Here.
Rosie?
Here.
Sandville?
Here.
Smith? Here. Stalker?
Here.
Vargas? I saw Xavier. Oh, maybe not. Okay,
He was here. I don't know what happened to him.
no problem. We'll see if he can pop back on. Okay, I'll go through our advisors. Oh, is that?
Yeah, sorry, the mic was
Oh, no problem.
incorrect.
Thank you. Okay. Justice Rodriguez,
Here.
Judge Juan Gutierrez, Judge Yang. All right, and our liaisons, Selena. Go
Present.
Lauren Klein.
Here.
Great. Melanie Snyder.
Present.
And then Yoon Kim. I don't know if she attends each time, but we have in our roster. I'll just make a note of State Bar staff that I see present, and then we'll just add them to the meeting minutes. We have 15 members and quorum.
Great. Thanks, Crystal. Let's go to public comment. Is there any members of the public?
Yes, we have one person with their hand raised. I'll let them speak.
Okay. And just a reminder, public comment, we're going to set it to 3 minutes. And as a reminder, it should be relevant to the jurisdiction of the Trust Fund Commission. Go ahead.
I couldn't remember whether to say good morning or good afternoon. Good afternoon. My name is Lee Farron. I'm a program director at One Justice. I am here today along with Sasha Steinberger, who's the founder and co-executive director at LegalLink, because over the last year, we've worked closely with more than 10 legal services organizations across California to develop a proposal for community justice workers in legal aid. And the proposal is on the agenda under item 6.4, the discussion regarding mapping the national landscape to expand access to legal services. And we just wanted to emphasize that we are still in the process of collecting feedback on the proposal and working with stakeholders. So there are some components that could change throughout that process. And also mention that we are, both Sasha and I are here and available to answer any questions about the process or the proposal itself as when the group gets to that discussion. We want to say we want to appreciate you all taking on that item and engaging in the discussion, and we look forward to hearing your thoughts and your feedback on the proposal. Thank you.
Thanks so much. It looks like Selena for public comment.
I'm only using this time because it's a consent agenda item, and I expect there not to be any discussion. I wanted to speak in support of the commission adopting the consent agenda items. Black in the community have submitted comment through various phases of that. And we're also in support of the approving the audit extensions and in support of staff recommendations.
Thanks, Selena. Any other public comment?
No.
Okay, I will note, as the commissioners received, we did receive a written public comment with regard to the audit extension issue. So just wanted to flag that. I think everyone's received it. Okay, let's move into then our next agenda item, which is the chair's report. So I'll provide just kind of a quick update on some developments that we've been engaged in. So as I think I told you all at our last meeting, we were going to present at the Judicial Council, which we did. Dwan and I attended that in the end of April, and it went really well. We told them about all of the amazing things that the commission's been doing and its effective grant administration. And so very exciting that we had that opportunity to share with the Judicial Council the work that we're doing. I also wanted to let you know, and this is related to an agenda item that's coming up with regard to a potential policy change that the Board of Trustees is considering at its meeting this Thursday and Friday with regard to whether we will have some additional autonomy with regard to legislative, some legislative advocacy. And so I'll be attending the Board of Trustees meeting to help with the presentation on that agenda item. And then finally, I did just want to flag, because we saw some emails, I think Crystal sent out emails asking for commissioners to work on scoring grant applications, which I think we had, as we were restructuring the commission, one of the things that was a point of debate, and one that we ultimately settled, was that commissioners wanted the ability to participate in scoring the grant applications, especially for new grants. I'll just note, it sounds like there was not a lot of ready volunteers for that. So I just encourage, if we would like to have that role of the commissioners being involved in scoring the grant applications, we really need to make sure we have people who are going to volunteer to actually undertake that work. So just an encouragement on that front. On the one hand, it is like a fair amount of work, but on the other hand, it's a great opportunity for you to see the kind of work that the legal service organizations do and the kind of proposals that they put in, and to really get like a really close view about how the grants get assessed and scored, and how we come to those decisions. So just encouraging. Catherine, you have your hand raised on this.
Thanks. Can you just remind us what the opportunities are? I responded to the Care Court one, but I wasn't aware if there were other ones at the moment that we should be considering.
Sure. The second one was the partnership grant applications. I think I sent an email around April or so, and this one was a little bit of a more time commitment. I think we're anticipating around 30 to 40 applications. So sort of the time commitment is a little larger than the Care Court application.
Thank you.
Tony?
Do we have dates set yet? And if so, like for scoring, just so we can check.
Yes, I think in both of the emails we had put the anticipated scoring dates, and they both fell, I believe, in the second or third week of June. I believe at this point, and I'll just follow up with the grant leads, that I think we have enough commissioners secured for scoring this year, and they'll follow up with those folks. But those dates were included. I think we're trying to like give as much information as possible, and scheduling as well. That was planned around the scoring schedule.
Yeah, and I'll just make note that we'd love to have like the commissioners involved. We think you bring such a wealth of knowledge, but maybe there's a better way that we can communicate this through. We can try to do it like at the end of the year to give you guys an indication what's happening through the year, so you can figure out. I mean, we've been sending emails, and I do want to share that like our staff sent out several emails, and then we end up going down and calling commissioners just because we weren't getting it. So we do now have enough, but it was time consuming for the staff to have to call commissioner by commissioner to get it. So if there's a better way to kind of communicate these opportunities, maybe at the end of the year, so you have the full slate of it. And they do really vary, like the partnership grants, like Crystal said. Our sense is that one probably didn't have a lot of takers because of the time commitment was large. We had 30 or 40. We're going to be receiving 30 or 40 applications, whereas Care Court, it's really only a handful. So it's a lot less. So, I mean, let us know what is tenable for you all so that for next year we can like adjust. But we do, I think at this point, have enough volunteers though. So thank you.
Great. Thanks all. So that's all that I have in my report, unless anyone has questions for me. Seeing no hands raised, I'll turn it over to Duan to give third director's report.
Great. Hi everyone, good afternoon. I just have a few updates. And if you might have already heard some of these at committee meetings. I wanted to give you a legislative update. So as you and all know, we advanced a slate of both funding and policy proposals to the legislature alongside LAC. I would say that they were pretty much positively received on all fronts. However, if you've been following the news, the state budget is pretty in dire straits right now. So we don't know how likely that is. We are still doing all we can to continue the conversations with legislative staff and the governor's office, and we'll keep you posted. We probably won't know if there's like positive movement on that front for probably a few more months. Then there are a whole slate of other like non-funding policy, and that is like getting a little bit more traction. But again, nothing is in print yet. We don't know, and we will, if there's more movement, we will send around kind of an update to you all, even if it's before the commission meeting. So just know that we're still on that and trying to advance those proposals. My second update is last week there was an Equal Justice Conference hosted by the ABA and the National Legal Aid Defenders Association. I just want to call out our own Judge Yang was part of the host committee and made opening remarks. Selena was also part of the host committee. It was there. And then we had staff members also presented on 2 panels. So Jennifer presented with 2 of our grantees, the Legal Aid Association of San Bernardino, also the Lawyers Committee for Civil Rights on a tech panel that was really a lot of people attended. There was really great questions and discussion. And Elizabeth in our office, our other director, as well as Lisa and another, she is in our Office of Research and Statistics. They co-presented, they previewed the Justice Gap study. And then related to that, I wanted to let you know that the Justice Gap study is going to be published next week. As you all know, we had previewed some of the preliminary findings at the December commission meeting, and then you all delegated authority to both Erica and Amin to kind of work with staff on providing some kind of recommendations as part of the Justice Gap study. So we will send that around. We're just so happy and so pleased. You will see there are several parts to Justice Gap study. A lot of this will impact our work. And at the next commission meeting, we will have a fuller presentation from Elizabeth and Lisa and Erica and Angela, who in our office, who worked really heavily on writing portions of the Justice Gap study and doing the research along our RS department. So you'll hear kind of the Justice Gap study, and then the commission can decide if there are any projects that we want to modify based on kind of that data, or to add on to kind of our work plan. So more to come, but we're just like very thrilled that that is happening. So that will come out next week. And that is all I have for my updates. I'll turn it back over to you, Erica.
Great. Okay, so then did we, I should just confirm, are Melanie and Selena also going to provide their updates during this point?
Oh, yes. Thank you for that reminder. Sorry, Selena, you're like mid-bite. Melanie, do you want to go first if you have any updates from the Judicial Council?
I do have a big update. I don't know if you've all heard the news, but the AmeriCorps program was terminated federally. So it's just making a huge dent and a lot of issues to work through for our self-help centers. We had a big Justice Corps program that was in the Bay Area, San Diego, and Los Angeles, and employed about 300 members, Justice Corps members, at various levels. Some of them served 1 day a week, and some of them served full time. And so just trying to figure out how are we going to you know, how are we going to backfill self-help? What's going to happen in Los Angeles without 40 something full-time members and a you know, a couple hundred volunteers that are members that served 1 day a week. So it's just devastating. And so that's something that's definitely going on around here. And so we may be trying to figure out other solutions, and it might involve some legal aid cooperative, but who knows? And so on the good side is that it's offering us an opportunity to really think outside the box and try to come up with solutions that will sustain longer. So I think that's probably what we've got going on. I guess we are wrapping up our fiscal year, so we will start again once the budget comes out. We looked at the May revise. To me, it looks pretty like a flat funded year for most everything. And so we are already starting to dust off our contract templates and get them ready. Our goal is to just, soon as fiscal reopens, get your guys are top of the list, and we will get that funding flowing. Excuse me. So that's my report.
Great. Selena?
I'll keep my updates short because I know we have a packed agenda, but this is really relevant for all of your grantees. As we've reported over the past couple of meetings, there are threats to federal funding, which would greatly impact all of your grantees. California receives something like 160 million in federal funding for legal services across several different funding sources. And the State Bar just collected data from all of your grantees last week, so you know an updated number for 2024. But just reiterating, there's a lot of instability with federal funding freezes and pauses and holds and litigation. But the community has been incredibly resilient. We're all talking with each other. A lot of organizations are looking at local advocacy, doing coordinated messaging to various Congress people and other federal legislators and state legislators. So your grantees are paying attention, and we're also working together. I know several of you may be aware of some of the kind of underlying threats to nonprofit status that might impact some of your grantees based on the current language being kicked around. And I wanted to assure you that the community is talking to each other, and our national partners have convened various webinars and opportunities to follow what's going on. So I know a lot of you follow the news and may be thinking about your role as a trust fund commissioner and how you can protect your grantees. And I just wanted to reassure you that we are talking to each other, and we have a lot of experts in DC who are really helping us navigate these issues. And the other thing I wanted to share is just like the feel good. We hosted an executive director retreat just a few weeks ago. The State Bar actually heavily subsidized the cost so that organizations could participate. And it really was a fantastic event with everyone who is facing this just extreme uncertainty, restructures, trying to really pivot to respond to disasters and changing federal landscape. Having the opportunity for folks to talk to each other, there was just the connection was, I can't stress enough how important it is for us to connect in person and remember why we chose to do this work. So thank you for financially supporting the event to make it more possible. And Ken.
Yeah, I just want to thank you, Selena, for the work that you did with respect to that convening. And I want to thank the State Bar staff and the Trust Fund Commission for providing funding for it. As Selena, I know you know, I was for many, many years a sort of a broken record on the issue of why it was that only LSC project directors were convening statewide and non-LSC funded IOLTA funded organizations were not meeting statewide. So I'm very glad to see that you brought everyone together. I think those kind of collective convenings can be extremely important.
I would be happy to do a formal presentation at a future meeting that's not so jam-packed with events. We have the event is hosted by LAC and One Justice. We work together on this, and we have done a formal presentation, I believe, after our second executive director retreat, but this is now the third annual executive director retreat. All IOLTA funded executive directors are eligible to attend. We also have hosted one deputy director retreat. We're planning another one for later this year because we think of that as our pipeline. And also, even if a deputy director never wants to be an executive director, they are in leadership and really help drive the vision of the organization. So I'd be happy to do a formal report. I've already shared with State Bar staff that the very informal feedback from all the attendees. But Ken, you're right. There has not been a way for non-LSC funded IOLTA programs to really gather until we created this space.
Thanks.
Great. Thank you all for the updates, and sounds like some really interesting developments. So appreciate sharing that. Any other questions or comments before we move to the next one? Next agenda item. Okay. See no hands. I'm going to take us to agenda item 3, which is the committee reports. I'm going to go first in providing just a quick update from the April 30th XCOM meeting. So at that meeting, we considered is going to be an agenda item a little further down, the IOLTA distribution recommendation. This is the first time actually since, and it's in part of our restructuring, that we've actually had the IOLTA distribution recommendation go through a committee. This time it's going through, it's going through XCOM. So we did a review, we voted and then made an approval and a recommendation to the full commission. This is the first time we've done that. In the past, it's just come to the commission directly. So excited to have that conversation with the rest of the commission and see how everyone feels about the recommendations that that XCOM has made. The other thing we did was we talked about the survey results from our in-person meeting in February and some suggestions for how to, I think it's the survey results, everyone seemed to agree that they liked having kind of a one-day in-person meeting. One thing we talked about is trying to do it not in LA or the Bay Area, and trying to go into different areas, in Central Valley. One other thought we had was maybe coming to Sacramento, but basically trying to get folks kind of outside of one hub or the other, and also have that speak to the fact that a lot of our organizations serve outside of those hubs as well. And then finally, we also started discussing ways in which we can engage our alumni commissioners. One thing that I've had some concerns about is that we, when people term off, I worry that we lose some really important institutional knowledge, expertise, and people that, could be very helpful to us. So we're thinking about putting together a kind of a spreadsheet and doing sort of exit interviews as commissioners term off or decide to, not continue with commission, so that we can find out what worked, what didn't, and what kinds of things they're willing to help with and participate with, and, the degree of involvement they're interested in having going forward, so that we can engage them. The other suggestion that someone made, which I thought was really a great idea, was having alumni mentor the new commissioners. It can be often, as you know, quite time intensive to be sort of an active commissioner, especially if you're in a leadership role or something like that. And so having alumni who are willing to kind of provide some of those details to newer commissioners might be a good way if folks who are terming off are up for doing that. Okay. So that's my report from XCOM. I'm going to turn it over to, I think it's Heidi, who's going to be doing this for the Grant Eligibility and Support Committee. Do we have Heidi? I'm not sure.
Crystal, do we have Heidi?
She's on the attendee poll. I think Kim is elevating her now.
Oh, okay, great. Sorry, there's a little bit of dead air, so I was having a moment.
Yeah, sorry.
Okay, there's Heidi. No,
Here I
you're
am.
fine.
Good afternoon, everybody. Jason is not able to be at the meeting today, and so I'm going to report out on the GES committee. At the GES committee meeting in May, they addressed compliance issues such as approving late audits, which you'll see on the consent agenda today, and grants with budget deviations that exceed the 10% threshold. We also discussed preparing for the IOLTA EAF eligibility application season, where we've received 120 applications, 6 of whom are new applicants. And the review process has begun, and the GES committee will be creating working groups as needed for eligibility review conferences for applicants that require further evaluation of their eligibility. And then the remaining eligibility concerns will be addressed at the July GES committee meeting. Also, we discussed the monitoring visits for 2026. As a reminder, grantees are monitored every 3 years, and the first year they are funded, and then as necessary during mid-cycle if there's compliance issues that warrants an additional monitoring visit. This year we'll be monitoring 41 programs. The majority of them will be via Zoom, except for the new grantees where we do try to do on-site visits. And we'd like to encourage and welcome or ask the commissioners to participate in these monitoring visits. We will be sending out a list of the monitoring visits and the scheduled dates. And if you are interested, we would you can respond back to the email and let us know which grantees might work for your schedule. We just ask that you let us know, 2 weeks prior to the scheduled date so that we can coordinate internally. And yeah, that's it. We just want to welcome you. It's a good way to learn about the programs and the different, the nitty gritty. So we'd love to have commissioners join us in those visits. And that's it for me.
Great. Thanks, Heidi. Any questions or comments? Okay, I don't see any hands raised. I'll just note I've been on a monitoring visit. I thought it was actually really, really interesting. So highly encourage commissioners who haven't, or even if you have, to take the opportunity. It's a good way to see kind of the nitty gritty again of the work that we do. Okay, now I'm going to turn to Judge Rossi, who's going to give us an update from the Program Development and Impact Committee.
Thanks, Erica. Hi, everyone. So the PDI committee met on May 6th to discuss how the State Bar and the Commission can support grantees. As a reminder, we sort of have 3 ways that we're doing that, looking at this year. The first is how we're using new and emerging technologies to assist. The second one is they're talking about the rapidly changing federal and state policy landscape, which we've already heard something about this afternoon. And then the third area that we're looking at this year is preparing and responding for natural disasters. So on the emerging technology front, we had a presentation from State Bar staff and Justin from Harbor Labs on how legal technology and generative AI relate to access to justice and how they can help our grantees really, do more work or do better work or more efficient work. So the grantees have, there's a pool of grantees that have been using this new legal technology. State Bar staff has been talking about this. There's a very detailed report. I'm not going to go into all the recommendations that the Harbor report came out with because there's quite a few. And I don't know, I guess everyone has access to it. Chris, maybe you know the answer to that better than I do, but I know we saw it at the PDI committee, but hopefully everyone will have access to that report as well. And you can see the work that's being done, the recommendations that have been made, and then how we're going to move through that in the next 6 to 12 months. And Chris is sipping something, so maybe you can give me.
I was going to wait till you flagged me again. I'm sorry. I'm also not remembering if we have posted it yet for a full Legal Services Trust Fund Commission meeting. but, and this might be where you're going, the PDI committee has formed a working group to dig into the findings recommendations, I believe, with the hope of coming back to the PDI committee and then eventually the full commission with which recommendations it supports most, or like which ones it thinks the commission should prioritize. And I think there will be a moment where the full commission will really grapple with it.
And, you know, we could send out the actually the report now, and then when we come back to the full commission from the PDI's recommendation, then that you can put it all together. But just a note on Harbor, we did contract with them to kind of help us with like the statewide assessment, and that's the series of recommendations that Judge Rossi is talking about, that now the PDI committee is going to really hone in on and kind of figure out which ones we will actually adopt and which ones we won't, and then we'll bring it back to the commission.
Yeah. Thanks, Juan. Thanks, Chris. And right, we did form a working group. I think it's myself and I think Vanetta's there and Jackie's there as well. And so we will be taking a look at this. But if it's posted and other commissioners have thoughts, please feel free to reach out to me or Chris or Juan about that. So we're also taking a look, as I said, on the changing federal and state policy landscape. We heard from State Bar staff about the March 2025 convenings that lack in the State Bar held for grantees in LA and San Francisco. Some of the things that we heard about, we talked about, were the sudden increases, obviously, in client legal needs, especially in the areas of immigration. As Selena said, funding becoming much more unpredictable since the end of January. We're going to hear probably more about that. And then the impact of current events on staff, on legal aid staff, including burnout issues. So we heard quite a bit on that. After that discussion, we had 2 committee members who volunteered to help staff explore how the commission can support grantees as the public policies continue to swing. I think that's Ken. I think you volunteered for that, and Afreen as well. You know, so we're just that discussion will talk about, you know, really how we can bring strategies to future committee meetings, especially to the entire commission. So look forward to that in the future at a full commission meeting. Then the last thing that we talked about was the disaster relief. We heard from State Board staff about the need for continuing funding of disaster legal services in California. We've talked about that. I know as a full commission, PDI is going to really jump deeper into that. So we talked about obviously the increasing rate and severity of disasters, the new legal issues that arise from a disaster, the loss of federal funding for disaster legal services, and if there are some models for disaster legal service grants that that we can look at and maybe consider in the future. I think that's everything we talked about in our May 6th meeting. I know that we also have that legal aid data project working group that 2 of our members are on. Aaron and Ken, you're both on that. And that working group is starting to look at how we can collect and use the data from the grantees, which we talked about a little bit earlier as well. And then, you know, before we adopted the new charters, the PDI committee received authority to approve upcoming reallocation of the homelessness prevention or grant funds. And so staff is looking now at that, and we plan to take that up at our June 11th meeting. And in the future, I think, as we maybe talked about before, PDI won't likely be handling the reallocations, but because we already have a meeting set for June 11th, we're going to handle the 4 grants right now. Am I forgetting anything, Chris?
No, that was great.
Okay, good. It was a lot. I know. I apologize. this group tends to meet monthly, and so and we are looking at so much work. So if any of the other commissioners who are on the PDI committee, if I forgot something, please remind me. And I will apologize for forgetting. Any questions then about the work that PDI is doing right now? I don't see any.
Great. Thank you, Judge Rosie. Appreciate it.
Thanks.
Sounds like some really interesting things. I'm really glad that we have that PDI committee doing this innovative work. All right, let's turn now to Catherine to give us a report out from the Rules Committee.
Thanks so much. I was just going to add before that the California Access to Justice Commission has comments to the Justice Gap study that are going to the Board of Trustees. And since this committee is looking at that, I assume, Dwan, you could maybe just
Yeah,
forward
I'm happy to share that out. And then, you know what I also will share is at the board meeting on Thursday and Friday, of the approximate time Erica's agenda item will be going. And also there's a presentation on the Justice Gap study by our staff. So if you all want to tune in, then you're welcome to.
Terrific. Thank you. Anyway, on to rules. We have been focused on the codification of rules about support centers, which haven't really been looked at for a very long time. And the staff helpfully has sort of divided them into some tranches of discussion topics. And so we took the first ones of those up at our meeting in May. And then at a working group meeting, and then had a discussion with a full rules committee, which and members of the public to get comments about those. A lot of these are really definitional about an example, which is just an interesting holdover from 1980, is there's a requirement that support centers have an office in California. I think what we thought of as an office in 1980 might not be how we think of an office today. So that's just a small example of something we've been thinking about. What does that mean, and what would we want support centers to do? So we're starting in the second group of work. We'll go back to the Rules Committee at I think it's the early July meeting with some further discussion of those topics, which will be great. The feedback's been wonderful. The working committee, I just want to acknowledge both Tony and Amin have been really terrific partners in working on the working group. We're meeting about every month to go through a series of things and sort of wrestle with what do we think about them, but more importantly, what questions do we want to ask other people about them and gather input. And the intention, I think, at this point is to send out for public comment with LAC and do some focus groups on the first set of issues as soon as we get those finalized, and then a bit later in the summer, the second set of issues that we're going to be talking about. The other two things that we have been working on as a rules committee is we had a presentation from the General Counsel's office with their thinking about real property and what changes, if any, are need to be made into sort of a formal rule about those. I think we're expecting additional information from them at our next meeting. And then today you will see in, I think it's item 5.1, some rules that Heidi worked on with the prior rules committee. So we have not taken those back up, but proposals really about financial standards that the rules committee worked with Heidi on and is proposing. And that is it for us. Any questions? Tony, anything to add?
You did a wonderful job. Nothing to add from me.
Great. Awesome. Seeing no questions. Thank you to the Rules Committee and the working group in there. It was a very interesting discussion on the support centers. And so appreciate all the work that's and the thought that's going into that. Okay, why don't we turn now to our first voting-ish matter, which is agenda item 4.1, which is the approval of the February 28th open session minutes. Is there any comments or concerns about the minutes? Seeing no hands. Oh, Catherine, you're going to move? Okay, great. Catherine makes the motion. A second?
Second.
Is that Patience?
Yes.
Okay, thanks, Patience. Why don't we take our vote?
Sure. Alikani, Babcock,
Yes.
Blakemore,
Yes.
Campbell,
Yes.
Galkin, Gonzalez,
Yes.
Huang,
Yes.
King,
Yes.
Klein,
Yes.
Mahoney,
Yes.
Morales, Pryor,
Yes.
Judge Rosie,
Yes.
Sandville,
Yes.
Smith,
Yes.
Docker,
Yes.
Vargas,
Yes.
Escobedo, Milrod,
Yes.
Elseraff, Connolly.
Yes.
All right, that's 16 yeses, 0 nos. Motion passes.
Great. Okay, now we're going to move to our consent calendar. I'm going to, let's see. I'll let Ken first make his comment.
Well, I have a question either for you or for Dewan. I need to abstain from one part of one of the items on the consent agenda, but not the other parts of that item, nor from the other items on the consent agenda. And I don't quite know how to do that.
I think when you get to your voting item, you just say what it is, like
Okay, got
what
it.
exactly
Okay.
you're abstaining from, or on that
Got it.
item or organization, and then we'll get that all noted correctly.
Got it. Thanks.
Thanks, Ken. I'm actually going to request that we take the audit extension request off the consent calendar, just in light of the fact that we actually got a public comment in opposition to the approval of that. So I think that warrants at least a little bit of discussion. So if we can pull off 5.3, and we'll consider that right after. With regard to 5.1 and 5.2, is there any other request to pull anything off the consent calendar? Okay, seeing none, do we have a motion to approve the matters on the consent calendar?
So moved.
Thanks, Patient. Second?
I'll second.
Couldn't see. I saw Angie, but I couldn't see who else.
I think Angie's
Priscilla, did you-
seconded. Yeah, the
Okay.
motion. Okay. I'll go ahead and take roll call vote. Alikani, Babcock,
Yes.
Blakemore,
Yes.
Campbell,
Yes.
Galkin, Gonzalez,
Yes.
Huang,
Yes.
King,
Yes.
Klein, Judge Klein,
Yes.
Mahoney,
Yes.
Morales, Pryor,
Yes.
Judge Rosie,
Yes.
Sandville,
Yes.
Smith,
Yes.
Stalker,
Yes.
Vargas.
Yes.
Thank you. Escobedo, Milrod,
Yes.
Elseraff, Connolly,
Yes.
16 yeses, 0 nos. Motion passes.
Great. I'm actually turn it over to Angela. Just give us a quick run through of what happened with the audit or what's going on with the audit extension request. I think we have his materials, but just want to quickly have a discussion on it about why, given that we had a as an FYI, as I mentioned, there was a written public comment. Hopefully everyone saw that written public comment just stated that no audit extension request should be granted. And so I just want to have a quick overview as to GES's reasoning for granting the extension.
Okay, thank you. So my name is Angela O'Hara, and I am going to present briefly on agenda item 5.3, which is approval of the 2026 IOLTA EAF audit extension requests. Tiny bit of background, the audited or reviewed financial statements are required as part of IOLTA EAF application process. This is necessary to confirm an organization's qualified expenditures to determine eligibility, but it's also necessary to ultimately determine the amount of the grant award. The deadline for applicants to submit is May 1st, and staff has discretion to grant extensions through the application deadline, which was May 15th this year. Beyond the application deadline, the commission can grant an extension to submit the audited or reviewed financial statement upon a showing of extraordinary circumstances. If no extraordinary circumstances are present, the commission may grant such extensions with conditions. Per the State Bar's schedule of charges and deadlines, the audit or financial review must be submitted before staff calculates grant allocations. This is going to occur approximately around August 8th. Staff agreed to all extension requests through May 15th, and then 3 applicants submitted audit extension requests beyond that date. The 3 that were submitted, one was from Child Care Law Center, one was from LACBA Council for Justice, and one was from Public Law Center. And I'll go through the reasons they provided. So Child Care Law Center requested a submission date of May 31st due to staff changes, office relocation, and transition in executive leadership that process. LACBA Council for Justice. Council for Justice is in the process of separating from LACBA, and it was the first time doing an independent audit, and there was a delay in receiving LACBA financial information. So they requested a submission of June 15th. And Public Law Center had some leadership transitions that impacted their financial procedures. And then additionally, some key personnel experienced medical issues that caused additional delay. And so their request was for June 15th to submit the audit. At its May 7th meeting, the Grant Eligibility and Support Committee reviewed audit extension requests from applicants, found all 3 demonstrated extraordinary circumstances that would likely result in anticipated delays. The committee recommended that the commission grant the requests through the requested extension dates, and in any event, no later than June 15th, 2025. Partly anything later will just make it very difficult for staff to prepare final eligibility recommendations in time for the July 25th GES committee meeting that Heidi referenced earlier, and the August 8th commission meeting before tentative grant allocations are calculated. So that was what was in the memo that you all received. And the request today was to pass the resolution approving these 3 audit extension requests.
Thanks, Angela. Does anyone have any questions or comments on this? No. Erin?
Yeah, thanks. I just want to express my strong support for granting the extensions on these, and more generally, I think that this is an area where the schedule and the deadline could really be looked at. I mean, as Angela is describing, to me, these are extremely good, valid reasons to take a little bit of extra time, and a really good demonstration of how the audit is one of these things where you're totally dependent on many third parties. Your auditor, who is probably auditing several other legal aid organizations, all of whom have a May 1st deadline. And so they cannot guarantee that they are going to be able to get the audit done unless your books are done at a very specific time. And there really is an extreme time crunch around this time of year. So in my opinion, this isn't on the agenda for today, but the folks who are on a calendar year, fiscal year, really shouldn't have a May 1st deadline at all. It should be May 15th or June 1st. The folks on the July to June fiscal year, maybe this isn't as much of a problem, but it really is a difficult thing. This is completely a valid issue, and I strongly support approval.
Thanks, Erin. Catherine?
So just because I just want to, because there is a public comment, have any of these organizations had a challenge getting their audit submitted in the deadline if recently, or these are sort of all first time occurrences? Does anybody know that?
I did check, and these three organizations provided their audits within the deadline timeframe last year, so not a problem.
Yeah, I think historically we have been concerned about audits being late multiple years in a row. So it's just, I think, important given the public comment to show that this is not a reoccurring problem for the three organizations. And I also appreciate Erin's comments about just the timing problem, but it just feels like we want to demonstrate in our conversation that this is sort of a one-time exception for the organizations as well. So thanks for the information.
I can confirm that too. They're not repeat offenders, even beyond.
Thanks so much, Dawn.
Great. Patience?
I also want to point out each of these organizations notified staff way in advance. This was not last minute and, oh gosh, whoops. They were clearly aware of their obligations and intending to meet them. And I wish the person who was objecting had told us why, but since they didn't, I move that we approve 5.3.
Catherine will second.
I'll second that again.
I think Catherine actually seconded. Before we take the vote, is there any other comments or discussion that we should have on this? Okay, seeing no hands, why don't we go to our vote? And thank you all.
All right, Alikani? Babcock?
Yes, as to Child Care Law Center and LACPA Council for Justice, abstain as to Public Law Center.
Thank you. Blakemore?
Yes.
Campbell? Galkin? Gonzalez?
Yes.
Hong?
Yes.
Ing?
Yes.
Judge Klein?
Oh, yes.
Thank you. Mahoney?
Yes.
Morales? Pryor?
Yes.
Judge Rosie?
Yes.
Sandville?
Yes.
Smith?
Yes.
Stalker?
Yes.
Vargas?
Yes.
Escobedo? Milrod?
Yes.
Elsteroff? Connolly?
Yes.
All right, that's 15 yeses, 0 nos. Motion passes.
Great. Thank you all. Yeah, and I just briefly want to echo, while I think every year there's different requests that are made by different organizations, and we tend to try to be, conscientious to the particular circumstances. It may look like we have a pattern of being too liberal on this, but actually really what happens is every year out of our 100 organizations, there's going to be a few that have extraordinary circumstances. It's when there's really no justification, or if it's like a repeat issue, we have been very thoughtful about that. So just wanted to make that comment in light of the public comment. Okay, let's move now to, of course, I lost my agenda. Oh, here we go. Let's move now to business. We're actually going to take things a little out of order. We're going to do actually 6.4 first, unless anyone has any objection, but I hope not. And I'm going to turn this over to Jennifer to discuss mapping the national landscape to expand access to legal services, something that we obviously are very concerned about.
Thank you. Let me share my screen. Okay, can everyone see that? Great. All right. So again, my name is Jennifer Zelnick, and this is agenda item 6.4. As Dwan mentioned earlier, I will share a similar presentation with the Board of Trustees later this week. And to further situate this presentation, Dwan also mentioned that staff will release the 2024 Justice Gap Study next week. From this study, we know that despite the work of the State Bar and the Commission, California's justice gap has persisted, and in some respects, it has grown. One way that many states are addressing their own justice gaps is through licensure reform. The objective of my presentation is to demonstrate to the Commission how other jurisdictions are working to address their justice gaps through licensure reform, and then to share some high-level details about a grantee-led proposal for a licensure reform program in California. Licensure reform involves changing how the practice of law is regulated in order to increase the public's access to legal help. But what does this look like in practice? There are 5 major types of licensure reform. At their core, each of these programs is designed to increase access to legal services without violating a jurisdiction's rules surrounding the unauthorized practice of law, or UPL. Very briefly, UPL dictates who is and is not allowed to practice law, and it also determines what constitutes the practice of law. These rules are designed to protect the public. Now let's review what each of these types of programs means. An alternative business structure, or ABS, allows non-lawyers to own or manage a law firm and therefore share in the firm's fees. To implement an alternative business structure, states must abolish rules that generally prohibit lawyers and law firms from sharing fees with non-lawyers. An alternative pathway to licensure, or APL, is a means of licensing attorneys other than the traditional pathway. This could involve an apprenticeship, a portfolio exam, or a licensee agreeing to a certain number of years of public service. California's Law Office Study Program is one such example of APL. Next, a community justice worker is a trained non-attorney who can provide limited legal services to low-income individuals who are eligible for legal aid. Community justice workers, or CJWs, are not licensed and may only provide legal services under the supervision of an attorney who is employed by a legal aid organization or community-based organization. A paraprofessional is a trained legal services provider who is not an attorney. Paraprofessionals are licensed and regulated to provide limited legal services in specific practice areas. Many, but not all, paraprofessional programs permit paraprofessionals to practice without attorney supervision. Lastly, a regulatory sandbox is a space to test out new kinds of legal services and service providers that are otherwise disallowed under a jurisdiction's current regulatory framework in order to see if they can be implemented safely. Regulatory sandboxes often allow for participating entities to test out the other types of licensure reform that I've mentioned in this slide, as well as any other programs that might otherwise violate UPL. Regulatory sandboxes often include tech innovations, such as companies that use AI to do the work that would otherwise be done by an attorney. So now we'll examine what licensure reform looks like by jurisdiction. 25 states plus the District of Columbia, or over 49% of jurisdictions in the United States, have licensure reform programs that are active, in development, or under consideration. Of note, 3 states have licensure reform programs, that are inactive, deferred, or no longer under consideration. And these states are Florida, Illinois, and North Dakota. Additionally, please note that some states have some combination of different statuses, that is, active programs, programs under consideration or development, and programs that are inactive, deferred, or no longer under consideration. In those instances, the state is coded on this map to demonstrate its highest level of activity. For example, Washington is shown in dark blue because it has 2 active programs and 1 program that has been sunset. Similarly, California appears in dark blue because, again, we have an active alternative pathway to licensure program, although we also have a program that is no longer under consideration. Okay, so these next 3 slides show further details about the types of licensure reform by jurisdiction. Rather than reading them row by row, I want to call attention here to a few different rows. First, you'll see here that multiple jurisdictions have more than 1 program. While some states like Arizona have multiple active programs, other states like Delaware have multiple programs at different stages of implementation. Another important point to consider is that much of the licensure reform shown here is concentrated around paraprofessionals and CJWs. As with the previous slide, here I will highlight that several states have multiple types of licensure reform listed. On this slide, the most common type of reform shown is paraprofessionals, although programs range from active in Minnesota, New Hampshire, and Oregon to under consideration or development in several other states. I would be remiss when talking about licensure reform not to spend a moment discussing Washington. Washington was the first state to implement a paraprofessional program, which it did in 2012. However, as I noted earlier, Washington's paraprofessional program has sunset. This means that its 91 licensed paraprofessionals may remain licensed and may continue to practice, but no new paraprofessionals may be admitted. Conversely, its APL and regulatory sandboxes are active. Next, we will look more closely at a few examples of programs in operation. Alaska's Community Justice Workers Program emerged as a means to combat their state's intractable access to justice crisis, which is exacerbated by Alaska's massive geography and the absence of law schools in the state. CJWs emerged as a way to address the dearth of lawyers from within the state. In Alaska, CJWs are trusted community members who already work or volunteer in their communities. They can be students in university or law school, social workers, tribal leaders, healthcare workers, or others. CJWs in Alaska do not have education prerequisites beyond completing the free training that the Alaska Legal Services Corporation provides. The principle behind the lack of specific education requirements is that with good training and the knowledge these community members already have, they can effectively perform discrete, limited legal tasks. Alaska's CJW model has been studied by independent researchers, and the results are really promising. Within a 40-month period, CJWs secured approximately $23.7 million in direct SNAP benefits for clients, which averages out to over $500,000 per month. Additionally, to date, CJWs boast a 100% client satisfaction and success rate. Minnesota's Legal Practitioners, or LPs, started as a pilot in 2020 and became permanent as of January 1st, 2025, due to its success. This is a paraprofessional program. And importantly, the program is structured a little differently than some other paraprofessional programs because LPs must be supervised by an attorney. They may practice family and housing law only and can provide limited scope services. In some specific instances, they may appear in court. However, their services are still considered limited. They must satisfy educational requirements, which you can see here, ranging from a high school diploma and 5 years of substantive paralegal experience to a JD from an accredited law school. There are currently 30 LPs, and the program has received 0 complaints to date. Minnesota also found that in some instances, LPs were able to resolve cases faster than attorneys. For example, custody matters reached resolution an average of 50 days faster with an LP than with an attorney. And the third program I'll talk about briefly is Utah's Certified Advocate Partners Program, or CAP, which is a CJW program that was authorized through Utah's regulatory sandbox. So as a reminder, you saw earlier that Utah does not have a standalone CJW program, but it has authorized CJWs through the sandbox. CAP advocates are supervised by an attorney from Timpanogos Legal Center, which is a legal aid organization in Utah focused on family law. CAP advocates provide legal advice on civil protective orders and stalking injunctions to pro se survivors. There are currently 16 active CAP advocates, and in 3 years, these individuals have assisted over 350 clients. Over 3/4 of these clients live in rural Utah. CAP advocates are already embedded in their communities, specifically in domestic violence spaces. They must already have 2 or more years of victims advocacy, including experience with civil protective orders, in order to participate in the program. They undergo 50 or more hours of training, including training in ethics, legal writing, and rules of evidence. Now that we've examined what some other states have done to address their justice gaps through licensure reform, I wanted to briefly review the State Bar's efforts to date. As you can see, between 2018 and 2022, the Board of Trustees engaged in several efforts to close the justice gap through licensure reform. First, the board commissioned a legal market landscape report, which identified major shifts in California's legal market, from people law to corporate law. Based on these findings, the board formed the Task Force on Access Through Innovation of Legal Services, or ADLS, which was charged with identifying potential licensure changes to improve access to legal services. Drawing on ADLS's work, the Board of Trustees then formed 2 more working groups, the California Paraprofessional Working Group and the Closing the Justice Gap Working Group, both in the hopes of developing programs to shrink the justice gap. While the former was tasked with developing a paraprofessional program, the latter was formed to explore a regulatory sandbox to encourage additional types of legal innovation. Importantly, the paraprofessional working group was not without opposition from both the private bar and some grantees. Although the Board of Trustees approved the working group's recommendations and rules in May of 2022, only a few months later, in September 2022, AB 2958 passed, which prohibited the State Bar from advocating for a paraprofessional program and significantly limited its exploration of a sandbox. Of note, AB 2958 sunset on January 1st of this year, and that is in part why the board will also be hearing this presentation later this week. With this in mind, I want to shift now to a brief overview of the legal aid-led proposal for a California CJW program. In December 2024, a working group composed of State Bar-funded legal aid programs, the Legal Aid Association of California, and others published a CJW proposal for California. The proposal seeks to establish a program for CJWs to provide limited legal services to low-income Californians. Through the proposed program, CJWs would provide limited legal services under the supervision of legal aid organizations. The proposal recommends the Commission to authorize legal services organizations' CJW programs. The proposal also recommends that State Bar grantees, as well as legal aid organizations who are not State Bar grant recipients, could apply to the Commission to become authorized legal services organizations. The proposal contemplates a streamlined application process for State Bar grantees who already undergo extensive yearly vetting through their annual IOLTA application process. Under the proposal, authorized legal services organizations would be able to train and supervise CJWs to provide legal advice and other limited legal services under attorney supervision to Californians who are eligible for legal aid. Additionally, authorized LSOs would be required to report relevant changes to either their organizations or any individual CJW status and report certain types of data to the State Bar annually. This slide outlines the working group's proposed requirements for CJWs, namely that they cannot perform activities constituting the practice of law outside the scope of the program's certification. They cannot charge fees. CJWs must be affiliated with an authorized LSO, and they must meet specific conditions to transfer their affiliation. They cannot be disbarred or suspended attorneys in any jurisdiction, and they must adhere to all relevant rules and statutes. The working group proposed that the State Bar's role in the CJW program would be to maintain public rosters of authorized LSOs develop a process for authorized LSOs to certify individual CJWs to the state bar, and communicate to the legislature, Supreme Court, and any other relevant authorities about the authorized LSO and individual CJW rosters, as well as any complaints received against CJWs. The proposal recommends an assessment of the program after 5 years, including information about the number of CJWs and clients served, the impact of the program on participating LSOs, and program costs. Additionally, the proposal outlines 3 potential pathways that the working group has identified to address concerns about UPL. Broadly, these involve new rules of the court, a statutory waiver to Business and Professions Code 6215, and an order issued by the California Supreme Court. So now, to open the discussion, I'm happy to answer any questions about the presentation. Additionally, as mentioned earlier, the PDI committee plans to invite the authors of the proposal to present in more detail at its June meeting for the purpose of forming a working group to share feedback with the authors as they continue to refine their proposal. Ahead of that, does the commission have any questions it wishes the PDI committee or the working group to ask of the authors or edits it would like to suggest? And I can either field questions, or Erica, I would defer to you. I'll stop sharing my screen for now.
Okay, I saw Catherine raise her hand, so I'll let her go first, and then I think there's a lot of hands. So this is great. I'm excited for this discussion.
Thanks for the really terrific presentation. I guess just 3 things I might not have understood in the presentation, or maybe it's to be clarified, is, you know, we talk about LSOs, and is there a definition of a legal services organization? So I don't recall hearing that, so I guess I'm curious about that question. And then I think one of the places where this has the potential to work and not draw a lot of opposition is sort of this idea of being supervised. And I can't quite tell what the supervision structure is, because it was referred to as supervised by the LSO, which to me didn't necessarily suggest it needed to be an attorney supervising them, or what is attorney oversight, because I think that is the question that has most often come up. And then the third is, it talked about complaints potentially, and I couldn't tell if the complaints were coming to the commission, what the resources would need to, I don't know quite what we, meaning staff and a committee, are supposed to do with complaints. I mean, it was unauthorized practice of law. That seems like it has a place to go, but it seems like complaints could be on lots of different things, and I assume there's a workload associated with that, etc. And so I'm interested in that topic as well. So those are I'm not expecting answers today, just sort of flagging things I'd be interested in hearing how the committee wrestles with them.
Sure. So I can actually answer most of those, if not all.
Great.
So the first is, I believe that the authors of the proposal used the phrase legal services organization because they wanted it to be inclusive of both state bar grantees as well as non-IOLTA organizations in California. They used a specific definition in Business and Professions Code. I don't have the specific citation for that at the moment. I could find it for you in a minute. But basically, it's meant to be inclusive of organizations who are not state bar grantees. And again, there would be that bifurcated pathway. There would be a streamlined pathway for grantees and a more extensive application process for those who are not currently state bar grantees.
Jennifer, can I add something just on that point, and then you can go to your next one. The way, and Jennifer and I have read this pretty extensively and have talked to the authors too. Our understanding is, like, for IOLTA grantees, there would be a presumption that
I get that
we
part.
would
That makes
authorize a
sense.
waiver. There are pieces of proposal that obviously need to be fleshed out more, and we're hoping, like with the PDI and the working group, can flesh it out. So one of the things would be for the non-IOLTA programs, how do we establish eligibility? What are the specific criteria? And I think this goes, Catherine, to your question of like enforcement mechanism and how do we do that? So that the proposal actually doesn't have a lot of details of that. It's to our reading is it would be deferring to the commission to kind of outline that. So we think what should happen, and we would love to again work with the authors and the legal aid community with the help of PDI, is really to flesh all that out before the authors and this working group, they've already taken it to the legislature, but before they try to take it to the legislature again, I think those details would be really important. And then the other thing I do want to clarify that wasn't obvious already, Jennifer on one of her sides used the state bar and another side, the trust fund commission. The proposal, when you read it thoroughly, there is that distinction that the authors are making between the state bar. I mean, you know, it's Jennifer and I are state bar staff, and we're also your staff, so that's why it could be a little bit confusing. But there is the authors are making that distinction as the state bar is going to be the regulatory arm. They will promulgate rules around UPL, maybe have some additional rules about community justice workers. The commission's, though, his purview is the issuing of these waivers as to organizations, right? And how we do that is TBD. So there might be some overlap there, but it kind of depends on the complaint, right? I think your question, Catherine, if the complaint's coming through as an organizational complaint, I imagine that would be under the purview of the commission. Just like right now, we have a complaint process where clients can submit complaints about the organizations that we fund. Then with UPL, I imagine that would go to our colleagues in the Office of Trial.
Yeah.
So
That's, I mean, I guess what you're
two different
saying
paths.
is exactly why I was asking the question.
Yes.
I don't know, like, what are the parameters yet of a LSO? And that's why I was saying I wasn't expecting an answer today. It just seems like a question ripe for discussion. And I do think the workload question is important because we have money now to administer the IOLTA grants. And from what I can tell, people are very busy and have a lot of work, and it's a little hard for me to imagine taking on that workload as a part of this. It means I'm not opposed to the Trust Fund Commission doing this. I just think we have to be thoughtful about what is the initial and ongoing workload and how is that going to be funded if there's this expectation to do it right.
Yeah, and that's a good question because we certainly, as part of that feedback, we can scope that out, give you all kind of a budget proposal through PDI. Like the commission can talk about that, but I'll stop there because I think sorry, interrupted you, Jennifer. You're about to answer some of the other stuff.
No problem. I think you answered the third question, and just returning to your second question, Catherine, the supervision would be provided by an attorney at a legal services organization.
And it currently says that? Yeah.
It does.
Okay, great.
In the proposal,
I missed that. So that's good. I mean, I think it takes off the table a whole bunch of concerns that people have raised in the past.
Mm-hmm.
Great. Judge Rosie?
I don't think actually that I was next. I think Patience's hand was up before mine. I think.
Okay, sorry. I have like it in a circle in my phone. Okay, so Patience, you want to go?
Quickly, I've got the same questions Catherine had. And I'm really interested in what is the conceptual difference between a CJW and a paralegal. I love this idea. I think this has to happen in the legal profession, has to happen in the medical profession. Yes. I'm also like what attorney supervision really looks like. I'm wondering, and I'm curious about how, like who's supervising the supervisors. I mean, I get there's a lot to be worked out still, but that what Catherine gestured toward, which is the confidence that people can have that the public will be protected once these folks start working, that's really critical. So I'm interested in that, and I look forward to learning more as the issue gets fleshed out. Thank you.
Thank you. I'll just briefly say that, I think that supervision can look different in different iterations of CJW programs. But broadly, I think the difference between a CJW and A paralegal is the degree of supervision and the activities that they're enabled to perform. So a paralegal would not be able to give legal advice in the same way that a CJW would. And there would be obviously, again, supervision from an attorney, but there would be a slightly greater degree of autonomy for the CJW.
So my paralegals in my program would have kittens if all of a sudden they had colleagues who are CJWs and they didn't go to whatever, didn't get certified after a long training program and blah, 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 blah. I have no idea what the union would say. So this is like, there are a bunch of other complexities that are going to get layered onto this. Not to say they're necessarily legitimate objections to a good idea, but it's a real thing. It's going to be a real thing.
But I think it matters how we use the word paralegal anyway, because what legal aid programs do is different sometimes. Like, I think we had to report people for certain purposes as paralegals, but we didn't call them that.
But it's a good issue to raise, Patience.
Yeah.
And this is why we'd like to flesh it out. I mean, it's not just kind of the depth of the supervision, it's also the volume. In Alaska, I mean, they have a statutory waiver, so it's different in California than it would be in California, because we don't right now have one. I mean, they're like, their ratio is like 200 or 300 to 1 CJW. We couldn't even go there right now because there is no statutory waiver. So those are the types of issues I think that the commission could contemplate, work out, issue guidance, issue rules on the waiver piece. And the benefit of it being housed at the state bar for both the commission and then the other piece, if the board chooses to kind of engage in the other piece, is that our staff can, interface with OCTC, our OGC staff to kind of like have coordinated guidance on both fronts, on the UPL front as well as the waiver front.
Thanks, Eloina.
Yes, so one of the slides had the proposed requirements for the CJWs. And one requirement is that they cannot be a disbarred or suspended attorney in any jurisdiction. I'm just wondering if there has been any discussion or consideration about non-attorneys who have been investigated by the state bar and had a UPL cease and desist notice sent to them, whether or not they would also be sort of not allowed to participate in this program?
That's a great question. My several readings of the proposal did not, that doesn't come to mind. But I think it's a great point and something we can bring to the PDI committee as well. Thank you.
Eloina.
Oh, that was it. Thank you.
Great. Then I'll go to Tracy.
Yeah, hi. I wanted to thank Jennifer for that presentation. And I also wanted to thank the authors of the study who I believe are attending this meeting for all of the work that they've done. And I think one thing that struck me was slide 15 in Jennifer's presentation. And slide 15 points out that this is a legal aid-led proposal. And for those of us who were around during the earlier proposals, with respect to anyone who was involved in those efforts, it did feel from the grantee's perspective, and I was a grantee at the time, it did feel very much like things were being sort of jammed on us without our input, our involvement until fairly late in the game. And that put many, not all, but many legal aid programs in sort of an adversarial position with those who were pushing reform, which was not a very comfortable place to be. I think this effort has much more of a chance of succeeding because legal aid programs, along with LAC, have been brought in from the get-go. They're the ones generating the ideas. I will tell you, and all of the things that Catherine and Patience have mentioned are valid issues that need to be fleshed out as more details are developed in this proposal. But what's on paper right now is, in my opinion, I don't know, about 1,000 times more detailed than what we saw in the earlier proposals, where there really was virtually almost nothing in terms of talking about supervision or enforcement or how this would all work. And that was a great concern to many legal aid programs. And I think the thought and care that's gone into this study and the effort so far will help ease a number of concerns. Again, as Patience and Catherine mentioned, there will be questions that need to be answered. And I think the PDI committee working with staff can flesh many of those out. But I think we're a long way further with this study than we were with our last efforts, and a long way closer to actually having something that will work.
Thank you. Ken, I would just add that in addition to being legal aid led and with lax involvement as well, the State Bar was not involved in the development of this proposal. So it's even greater than that. We have not been involved.
Judge Rossi.
Yeah, I just wanted to say that that the PDI committee is made up of some pretty awesome folks, including Ken and Aaron and other folks who probably have thoughts on this. And so, you know, obviously we will do and try to answer all the questions that folks have about the proposal. And it sounds like Lee and Sasha and maybe others are gonna come to our June 11th meeting, and at least so we can start taking a look at this. And so, yeah, I think we just really look forward to hearing more about it.
Great. Lena?
I mean, just a very quick comment, because I know Ken and others have referenced that the primary authors are listening in as well. If there are questions about how this model is different, or how this model, as others have said, this was driven by the legal aid community to address a specific need. If there are questions, I think they would love to be able to answer them, perhaps even in written format, so that so people have time to kind of digest the differences. I know that having a PowerPoint presentation is not the same as reading a very long report and sitting in on multiple working group meetings, but there has been a lot of time and energy dedicated by not only the working group members, but other members of the community who have weighed in on how this model, if adopted, really could make a huge difference. And I also want to marry it with the Justice Gap study, which I know you'll be talking about later. We have a crisis. People do not trust lawyers. That is one of the primary reasons why people do not go to lawyers for help. Community justice workers, under a framework that we can establish has adequate supervision, they are already in the community, and they can be a bridge, a trust bridge, to help people who have a legal issue and would never go to a lawyer because they don't want to be judged for the bad decisions they made. You know, the bad decisions that someone may say they made, even if that's just fear-based and everything they did was fine, they have a legal problem, and community justice workers could help. So I would love it if folks had questions to pass them on to State Bar staff to make sure that the working group members and the primary authors could answer, because they've spent a really long time thinking about this.
Thanks, Lena. Aaron?
Yeah, thank you so much to everyone who's worked on this. And I really just echo, these are tremendous questions and comments. I really agree with everything everyone has said. I'm really excited to dig into this more. I have a bunch of questions that I'll save for, I think, our committee meeting, but maybe one that I might ask now, since the commission overall, deals with the money part, is, one of the criteria for the CJWs will be that they can't charge a fee to the clients. And so that raises the question, well, how do they get paid? So where will the money come? Is this a new funding stream that we're anticipating, or will be requesting from the legislature, or are we asking the legal services organizations to take on CJWs as staff, or, is what thoughts have already come up around that?
I could take that one, Jennifer. So, right now we actually allow, if a program right now wants to have a CJW, even though there's not like an official kind of standing statewide model yet, they can use IOLTA and EF funding. But I believe in conversations with kind of the authors and some members of this working group, I think the long-term goal is some type of dedicated funding stream from the legislature to make it more kind of tenable. So that would probably be the long term, and that would probably be something that the State Bar staff would support. report how much, how long, all those things are like, I think, TBD. And we are certainly would love to work with the working group and LAC to kind of figure out like the funding piece of it, because that is a really, really important component of the, but right now, currently though, they can use IOLTA and EF funding. There's not a prohibition on that. And then the other comment I wanted to make, since again, I want to thank like the legal aid working group. I want to thank kind of LAC on putting together such a really thoughtful proposal and inviting kind of the State Bar staff and now the commission to kind of engage in this, because I do think, like as Ken said, like there is a more chance of success this go around. And it seems like, we're having such a really great discussion here. And there are several members of the commission that seem very interested. That I want to invite you all, if you're interested and you're not part of the PDI committee, to really come and listen in at the next PDI committee and participate and give us comments. Like there are avenues for you to engage, even if you might not be officially part of the PDI committee.
Great. Thank you all. Very interesting discussion, and hopefully the authors have some interesting feedback that they can take back before they present to the PDI committee. I'll add my 2 cents just to kind of follow up on the point that Alina made, which is like the bar is not the only entity that regulates UPL. Our office, the Department of Justice does, local DAs do. They're just flagging. There's there may be other places where, to her point about people who've engaged in UPL in the past, should they qualify as TJWs and under what circumstances would be helpful. Anyway, okay. Thank you. Any other comments, questions on this discussion point? Great. And thanks to Sasha and Chris Kelly, who are elite who was there, who made public comment earlier in the first part of the report. All right, why don't we turn now to 6.1, which is the regarding our 2026 IOLTA distribution and a recommendation to the Board of Trustees. So I'll turn this one over to Dawn, Heidi, and Michael.
And Michael's actually on vacation, so it's going to be me and Heidi as soon as Heidi gets promoted. Okay,
I'm here.
Okay, great. So Heidi and I have a short kind of PowerPoint presentation, but we're only going to really hit kind of the high points. In your meeting materials, there's an extensive memo with a lot of background about kind of the statutory authorities, the leadership bank, how this program and the revenue stream, how that all works. But we'll hit some of the high level points. And one thing I do want to underscore is like, this item is kind of probably one of the most significant decision points that the commission makes every year. As you all know, the IOLTA grants is kind of what started this program. This is what started the funding for the Trust Fund Commission. So this is really our like flagship grant. This is the funding that is very core funding to creating kind of the infrastructure of civil legal services in California. And so the amount of money that you all decide, the recommendation that you all present to the commission, to the Board of Trustees, is very important in kind of like keeping that infrastructure intact. And then you'll hear, because it's based on kind of interest revenue, it's very volatile. So it's not an easy decision to make every year, but one of the core decisions you make in order to kind of smooth out that funding stream and have that stability for grantees. Okay, so kind of with that overview, Heidi, do you want to start the slides and then go through them? Okay, next slide. Okay, so we're gonna go through kind of some key dates since the last time we've done projections. We're gonna go over kind of the revenue stream, what our projections are for our investment, a little bit about the IOLTA statute, our reserve policy, and then Heidi, then I'm going to turn it over to Heidi to then go through all the numbers with you and the various projection. And as Erica mentioned at the top of the meeting, this is the first year that this item has gone through kind of extensive vetting from the executive committee, and I'm really kind of grateful for this change, because previously we had brought this item to the commission and it always felt like we never had enough time time to really dive in such a, used to be like an hour and a half, and then there were always like kind of pending questions. So now that it's been kind of vetted with the executive committee, we've gone back, we've provided additional information to the exec. We feel like at least there's like one more vetting. And so I think this is a structure that really works. Okay, with that, Heidi, next slide. Okay, so just a couple things to kind of a note that's also noted in the memo. Last year was the first time in several years that the Federal Reserve started interest rates started going down. We knew it was going to happen. We didn't know exactly when. So interest rates dropped. They were at 5.5% for several years, and then they dropped about 1% last year. So we ended the year at 4.5% in the interest rates. We are projecting, as you'll see, another interest rate drop for this year. There's still several more meetings that are happening at the Federal Reserve, and it's just been a really, really volatile. The Federal Reserve had motioned last year that they were going to begin dropping a little bit more aggressively. And if you guys have all following the news, because of everything that's happening with tariffs and with the market, the Feds now have kind of pulled back and have come out and have stated that the drops will be a little bit less. It's still very kind of unpredictable, but everybody, and we work with national consultants. We also consult with kind of other states and kind of how they're doing their projections, but everybody's kind of landing around this 1%. And as you'll see what Heidi goes through, we actually do build in a little bit buffer elsewhere in case kind of that 1% is a little bit more. But just know now that we're about 4.5% for the federal funds rate. And then, okay, yeah, go. Sorry, Heidi. Okay. Other thing to note is we call them IOLTA grants, but there's several kind of sources of revenue. IOLTA interest revenue is what makes up the bulk of IOLTA grants, but then there are return funds that come back from IOLTA grants, kind of go back. Our investments go into this. Justice Gap Fund donations, Cypre donations go into making kind of IOLTA grants. Next slide. This was our interest activity in the last year, and you'll see it's very healthy. We're about $10 million there, and this is because interest rates have just been kind of phenomenal the last few years. So the amount of money that we're able to hold in our bank account is generating, and we hold them in you'll see they're all kind of treasury funds, very safe investment. We do a 3-month investment. We hold enough back to make our cash flow and our quarterly payments. Otherwise, we invest it and it comes back. So it's been yielding just like really phenomenal rates. Next slide. This is a little bit background of Business Professions Code. I'm not going to belabor it too much, just to say that, the IOLTA statute was created in the early 80s, and then we went through one substantive change around kind of our IOLTA interest rates. It was in 2008, so that we are allowed to kind of require banks to provide for us comparable rate products. Before then, they were not required to do that. So that has really helped us during the last few years in terms of generating more income, especially when the pandemic hit and interest rates went to near zero. And then the other thing to note that is in 2019, we created a leadership bank program that has been just really, really, really successful. And banks that participate in the leadership bank program, they pay a little bit of a higher interest rates, and they also waive their fees for us. And that's generated a lot of income over the years. Next slide. Okay. The other thing to note is that we adopted a new reserve policy a few years ago. Our previous reserve policy, we had to project out several years in order to make the award determination. And then there was also like a formula of interest rates was rising. It locked us into this like 4-step calculation. We've redone the reserve policy to give the commission a lot more discretion and to also give the commission kind of guidance on what to do. And we're also now, one of the main things to keep in mind is we are doing a shorter projection. Previously, we had to project out 2 years. Now we're only projecting out through the year. So how it works is like, you see in your materials, and Heidi's going to go over this. We give you kind of actual revenue that we've already collected, and it's about a quarter right now. And then we need to project out for the remainder of the year. So everything that we collect in 2024 will then go out in 2025, and then you'll need to determine that projection. Previously, it was like we would need to project not just this year, but next year. So now we're doing a shorter projection, but we are pretty much distributing out less than what you determine for the reserve. And last year we held on a $25 million reserve, and we're proposing the same, to hold back $25 million reserve. But that's all obviously at the commission's discretion, whether you want to modify that amount. Okay, next slide, Heidi.
John?
Okay, and I'm going to turn over to Heidi now.
I'm doing all right. I'm boring.
Judge Klein, I don't think you're on mute right now, so you might want to mute while you're taking your phone call. Go ahead, Heidi.
All right, thanks, Erica and Dwan. So this slide here just kind of gives you some perspective on the last 10 years of the IOLTA grants distribution, as well as the EAF partnership and other grants. So you'll see that the red line is the total of all the grants we've distributed. So you do see that we've gone from, a low in 2015 of, like under $50 million to now hitting sort of over $300 million. So there's been exponential growth, especially as Dwan mentioned, from the interest rates changing and going up over the last few years. And that has brought us to, record-making grant distributions, which has led us to allowing for the 4-year spending for the IOLTA fund. So, so this just gives you an idea of just how rapid that growth has been. Okay, and so then, and this just says it more in this just shows the distribution amount. So for the current year, we distributed $251 million, which was, and the prior year was $95 million, and the year before that was $50 million. So we have just been on a steady streak up. So these are unusual numbers for the history of the IOLTA grant. And just this kind of gives you an idea of how the those distribution numbers came about, and sort of like where the interest rates have been over at the end of each year, and how much revenue has been received in IOLTA, and the change, and then what the grant distribution is. And so you can kind of see a little bit of the cause and effect of the interest rate changes over time. And so this is our this is the projections versus actuals for 2024. If you see the column on the left represents the projections and the distribution amount for 2024. And you'll see that we ended up with an additional $43 million that above what we had projected. So that's in part leading us to having a healthy amount to distribute for the 2026 year. Okay, so in going about, excuse me, I've got a little laryngitis, I apologize. In going about projecting how much we can distribute, one of the hardest things to predict is the interest revenue from the IOLTA banks. And so we've come up with a formula where we essentially multiply the average account balance in all IOLTA held bank accounts in California, and multiply that by a weighted average based on predictions of interest rates for the remainder of 2025. So sort of the variables we've considered are that IOLTA revenue will probably drop because we have gotten down in interest rates for the full year as opposed to last year. We're operating under the impression right now that interest rates will stay steady through until Q3, and at that point they may drop or may not. We are estimating our income projection from our interest on the funds we hold to be between $6.5 million to over $10 million, and so that depends on just how much money we're holding at the time and where interest rates are. Voluntary donations are expected to be $8.3 and $9.4 million. And this is higher than normal because we've had a very robust cypre season thus far. And so that has brought those numbers up more than they typically would be. And then there's always the possibility that the account balances in IOLTA accounts could drop. And we also wanted to recommend maintaining the $25 million restriction. So these are sort of the foundational elements for how we went about approaching the estimates. So as always, we've provided 3 different scenarios, and scenario A is just assumes account balances don't change, that they remain steady where they are, and they're at a record, $7 billion. So it's not a small number. And then also the federal funds rates wouldn't change over the year. So that's just sort of a status quo, sort of estimation. Option B, we reduced the account balances by 5%, and we did factored in 20.25 rate drop in September. It says and December. I'm sorry, there's an error on this sheet. It's only one rate drop for this particular item. And then for option C, we did another 5% deduction, a reduction of the account balance information, as well as 2 rate drops, one being in September, a 0.25%, and then again in December, going down an additional 0.25%, which would end the year at 4%. And so, and we had discussions in the executive committee meeting as to why we're using the account balance as a, and reducing that, and sort of, we're using that in part to just give us a little wiggle room in terms of contingencies and sort of, just building in a little, cushion and safety net. So that's the easiest way to, impact the formula. Okay, so scenario A. So after the executive committee met, at the request of Catherine, she asked us to provide some additional information. So we've done that, and I think it was a really good suggestion. So thank you, Catherine. So this is scenario A, and so we multiplied it using all 3 variables. So, account balance stays the same, account balance goes down by 5%, account balance goes by 10%, and then also no rate drops, 1 rate drops, and 2 rate drops. And so scenario A1 in this instance, it shows that's the scenario A projection. And so that's $178 million. Whereas in scenario A2, that would be 2 rate drops, and that's 170. It brings it down to $175 million with the same account balance. And then options or scenario A3 is sorry, that's 1 rate drop for scenario 2 and 2 rate drops for scenario A3. So that just shows you the impact of the allocation or the changes if you were to use the same revenue stream or account balance method. And then this is scenario 2, and so it's the same thing. It's assuming the same account balance. We calculated what the difference was between no rate drop, 1 rate drop, and 2 rate drops, and that's what's shown on this bottom line here. And so the scenario B2 is the scenario that is scenario B in the packet, and it is a scenario that the staff recommended, and it is the scenario that the executive committee also is recommending to the board. And so that is a reduction of account balances by 5% and 1 rate drop of 0.25. And so that would bring us.
Stay on this for a second, because I know there are a lot of numbers, just to let the commission kind of digest it. And one thing that we get asked this question a lot. So let me answer this before somebody asks. If you're projecting 166 million, then how come your ultimate recommendation is 217 million? Why is there that big difference there? So if it wasn't obvious to you, last year when we went to do projections, what we ended the year up, we had, you can think of it as the surplus. We had more than what we had projected. So that surplus is added to this, and that accounts for that difference between the 166 and the 217 number that we're recommending.
Right, and that's like when on the scenario that showed the various different pieces of what makes up the IOLTA pie. Those are the other pieces that Dwan is referencing, and those ones are more stable and predictable versus this one that is not stable and not predictable very easily. And so, and then lastly, we did the same thing for scenario C, which is the 10% drop. We multiplied it across the grant the interest rates. So no interest rate at that account balance, one interest rate at that account balance, and then two interest rates at that account balance. And so then in this scenario C3 is what the scenario C is on the recommendation sheet. Okay, or that's been presented. But this just shows you multiple options of how they how it impacts the grant. Okay, and so so these are examples of what we intend, or we believe we're going to be distributing next year in terms of grants. We are having, many of our grants are ending, and so they won't be going. So the IOLTA grant, we would, if we go with the proposal B, would distribute $217 million. The legal aid fellowship, roughly $1.5 million. EAF, assuming there's no cuts to the amount that's in the budget bill, it'd be $31 million. And also partnership is taken out of that same budget bill, and that's $3.5 million. And then care court is $15 million. So that brings us down to $69 million in distributions for 2026. The bank grants are ending, the care court or consumer debt is ending, Cal HFA will be ending in June, and we've also ended all of the HP grants. So there are a lot of additional discretionary grants that are not renewing. So, our grantees will fill that. And so this is the motion, I guess, but I'm assuming we'll go back to having a conversation and answer any questions at this point. So I'm going to go back to this field here.
Do you folks have questions about the different scenarios or the recommendation that the executive committee made?
I just wanted to thank Heidi for all her work, along with Michael and the rest of the team, and for doing this extra report, which might be the first time I actually understood how the different factors were influencing things. So it's really, really terrific, and I appreciate your work.
Oh, you're welcome. I think it was a great suggestion, and I do think it's easier for everybody to understand. So we do appreciate your feedback. It's never been this quiet after we do an IOLTA distribution projection.
Yeah.
This is not normal. It's
Am I taking Selena? Go ahead.
Well, only because Heidi said it's quiet. If we go back to the A, B, and C slide, I think that LAC is in support of B under staff recommendations. I think it's probably going to be closer to A because B assumes that there'll be a 5% reduction in IOLTA balances. And I think it's not necessary that would happen, but I understand that now is a time to be a little bit cautious in case there are other variables that we haven't projected, like if it drops more than that. So we're in support of B. We think it's prudent. I think we're going to see a lot of shakeups in our community with potential losses of federal funding, with what may feel like an equal access fund decrease because of new programs. And so having a robust IOLTA distribution is really important.
Thanks, Lena. On.
I just want to add, we actually at the executive committee, we had an extensive kind of conversation about what happens if this is the year where the staff's recommendation and projection is off, or because it's so volatile right now. What if Jerome Powell isn't at the feds, and there are all these kind of scenario planning. So I was asked to kind of go back and kind of look at our calendar and kind of think about what would be our course of action if interest rates dropped a lot more than we anticipated. So I have a couple things to report. So I looked at our meeting calendar. We have a meeting on August 8th, And then there is a board meeting in September. So this item's set to go to the board in September, and it's a little bit different this year. That's why we're meeting a little bit earlier, because usually there's like a July board meeting. That's not happening this year. They went from 6 meetings down to 4. So because of a late September meeting, we could potentially say interest rates start dropping and our projections are very off. What we would do, staff would bring back a modified recommendation for you at the August 8th meeting, and then we would get a change to go in time for the board meeting. I've also talked extensively to executive staff in the off chance that what happens between the September and like November, December, and things go near 0, 1%, 2%. Is there a way to go back to the board? And the answer was yes, of course. So the board needs a meeting again in November, but most likely they're gonna have monthly meetings because of everything right now that's happening with the bar exam. So I was told that you can agendize it, not to worry about that. If you need us to move nimbly, we will be responsive to the commission and the community. So that's like worst case scenario. We also, just to remind you, if you agree with the recommendation, there is the $25 million reserve. So if things go kind of the other direction and our projections don't kind of meet that, the commission has discretion to kind of dip into that reserve and kind of pay. What the staff would like to kind of avoid is modifying kind of an award once we have given kind of the allocation to the grantees. You know, they budget for it. It's just very tough to go back and either like claw back money. Even if we haven't officially sent out the money, they have to do budgets. It's a lot of work for programs. It's a lot of work for us. We never want to be in that position, but we understand there's just a lot of volatility. So there is like 2 backup plans. And so rest assured, if that has to happen, the one thing that we ask the commission is for your flexibility, and perhaps hopefully it'll just line up if that even happens. If not, then we would need to either call an additional commission meeting, or the commission can delegate it to XCOM. But we do have a plan in place if that happens.
And I'd just like to add to that one. There's 5 meetings left of the Federal Fund Reserve this throughout for the rest of the year. Only 4 of those would impact this year, because whenever the rate changes, it doesn't go into effect until the next month. So there's really only 4 opportunities for additional, reductions. And Michael and I did play with it. We're at May 21st, so we have a lot of this income already based on the the 4.5 revenue or interest rates now. And so we have to, sort of get to, and I don't remember, I forgot to look and tell you what we have right now. So even if interest rates drop to 0 starting in July, which I believe is the next, we would have enough, we might have to use the reserve to cover option B. So even if, worst case scenario, it just bottoms out and there's 0 interest rates, we would be okay for 2025 or 6 using the option B, and perhaps dipping into the reserve if necessary. Catherine?
So I was going to make a motion, but I see Robert has a question, so I want to make sure people can talk. I kept trying to get at the end of the line to do that, but I'll just take my hand.
Robert?
I was just curious, what are the criteria for increasing the reserve from the 25 million to 40 million?
Yeah, I can take that one.
Go ahead, thanks.
So when we redid the reserve policy, and you actually have discretion to that 25 million is a suggested amount. That's the way the reserve policy is written. So the commission has kind of discretion to increase that. But we did talk extensively with that working group that worked on this reserve policy, and it really is a year by year, but it's not tenable really to hold back, say like 40 million or 50 million. We had once the staff had once wanted to hold back a little bit more so that we can kind of smooth out the dips. There's a funding crisis right now. It would not be a great look, I think, for the commission to hold back that much, given that we also are asking the state for equal access funding, then to hold back and have 40 or 50 million dollars in just doesn't seem tenable. I think politically, if you wanted to go up to like 30 million, that might be probably okay. I think if we went up to 40 or 50 million dollars, it's would make me a little bit nervous. And maybe that's at a point where we need to kind of reach out to the legislature and give them a heads up just to make sure that everybody is comfortable with that amount. $25 million seems comfortable to make our kind of monthly payments, our cash, for cash flows. I think people understand we're a high distribution, holding back 25 million. We're getting to the 40, 50 feels just a little bit too much. Ken? And I hope that answers your question, Robert.
Yeah, and I think, Dwan, your answer makes a lot of sense in response to Robert's question. And I do think it would be a political problem to be having a reserve that's larger than the amount of the EAF grant. I think that particularly would be a problem for the legislature. My question has to do with the Board of Trustees meeting in September. So, and I apologize, it's been a while since I've been actually doing IOLTA budgets as a grantee, but my recollection is that we've got 30 days after, grantees have 30 days after their notification of their award amount to submit a budget. Now, do we tell grantees of the tentative amount that the Trust Fund Commission has approved before it goes to the Board of Trustees?
That's a really great question. And thank you. I forgot to highlight this in my presentation. So because the board moved from 6 meetings to 4 meetings, and we had already set our meeting schedules, we actually didn't go back and modify the commission's meeting schedule, because historically, this item goes to the commission's June meeting, and then right after that, in July, the board approves it, and then we run the allocation, and then we release it. So by the time we release the kind of the award allocations to perm, the board has already approved it. This year, it's not that way. We are going to be releasing budgets and award allocation based on the commission's, if you all agree, to 217, and then we will then go to the board meeting and ask for their approval. We do not anticipate that they will modify the commission's recommendation. And in fact, in the memo that we draft, the commission, I mean, the board has actually very limited purview in kind of modifying it. As you'll recall, you all are kind of codified in authority. The board can only overturn a decision if it conflicts with a fiduciary, statutory, or contractual obligation. This quite doesn't fall into this. We have been continuing to take this item to the board. I mean, so that they can make sure that that doesn't. But, we have OGC review this. We work alongside Brady and Raul to get this recommendation to make sure we're not skirting anything. We're complying with our own reserve policy. So by the time it goes to the board, there's already a phrasing that OGC has already reviewed this. This does not conflict with the statutory. But they still have to cross the T's, so it's not official until they vote. But there's honestly virtually little chance that would happen.
And that'll start the 30-day clock running. But as a practical matter, people will have, say, 45 or 50 days to figure out their budgets. Is that what I'm hearing?
Yes, they have 30 days to figure out their budgets. But what we've been trying to do a better job at communicating. So actually, Crystal's already preemptively drafted an email to go out later today to let programs know what the distribution is. And then programs immediately they start to kind of plan. And, there are a lot of programs. We've been trying to be really transparent with this. We do, every time we give you a revenue projection, we send out an email. So they already kind of know this number is out there. Last year, we had given the number that we were hopeful would be 185. And then at the end of the year, when the revenue came in more, we modified that. So they already kind of know the number is out there. And we all give all the caveats, like this year, actually, we're getting 6 new grantees. So that's going to impact allocations, right? So they can't just use that number. It's going to depend on their qualified expenditures, but that's what we do so that they can help scenario plan. What we don't want, and we've been told that, in the past, we would send out kind of like the number after the board meets, and then that's like August or September, where, now we have a sense of what the number is. So we send it out earlier. And so a lot of programs are already planning. Obviously, people like it when it's official, but they know about the whole Board of Trustees things. I shared this information with them at anybody calls. So it's all very transparent.
That's great.
And the other thing I would add is, you have to submit the budget in 30 days and it has to be approved by the commission. But once you get into the grant year, we have opportunities for budget modifications, and a lot of grantees take advantage of that because, what you plan in August of the prior year may not have any bearing when you come to January. So budget modifications are something that we can process and, are not a big deal to sort of, if a program needs to reorient how they need to spend the funds, then that can be done.
Great. Well, if we have no further questions or discussions, is anyone willing to make the motion to adopt the recommendation?
I would move approval. Catherine, you moved, I'll second.
Either way is good.
Great.
Great. I'll take roll call vote. Alakani, Babcock,
Yes.
Blakemore,
Yes.
Campbell,
Yes.
Dalkin, Gonzalez,
Yes.
Wong,
Yes.
King,
Yes.
Judge Klein,
Yes.
Mahoney,
Yes.
Morales, Pryor,
Yes.
Judge Rosie,
Yes.
Sandville,
Yes.
Smith,
Yes.
Stalker,
Yes.
Vargas,
Yes.
Escobedo, Milrod,
Yes.
El Connolly,
Yes.
and that's 16 yeses, 0 nos, motion passes.
Great. Thank you all very much. Very exciting. It's going to be, hopefully these funds will be really helpful to the community. And I think you struck, I hope the right tone, you know, where we are distributing a lot of funds, but are also thoughtful in case things change unpredictably. Okay, let's move on to 6.2. And Dawn, my understanding is there's no PowerPoint for this one. I think Dawn and I are going to present on it. So I should probably, I don't know, Dawn, do you want to take the lead on this, or would you like me to talk?
I think if you can, because you're going to present, it's, you know, to the board. too.
Perfect. Yeah, that's fine. It looked like you came off mute, so I had a moment where I was like, ah. Okay, so as I mentioned earlier, I'm going to the Board of Trustees meeting, which is happening tomorrow and Friday. One of the things that the Board of Trustees is considering at our suggestion and with our input is a revision to their legislative policies regarding the requirement for certain direct legislative advocacy to go through the Board of Trustees for approval before we can do that kind of advocacy. So I'll give an example. When the legislature did the emergency session, the special session during the winter time, and we were advocating for additional funding for LSOs, we did a letter in support of the legislation for that additional funds, but that letter had to go through, get the Board of Trustees to also sign off. And so one suggestion that we are making is that in light of SB 211, which passed, 4 or 5 years ago now, that really for matters within our core jurisdiction, which is really about IOLTA funding, EAF funding, and similar grants, that the Trust Fund Commission will have the ability to engage with the legislature, you know, put letters of support in for that legislation, and without having to get the board's approval, and also can do it with their own name on it, Trust Commission's name. As part of that proposed policy, we will need to have commission approval for any of those legislative activities. This suggestion here, that the motion that I'm and the memo that we put on as an agenda item would essentially delegate from the commission to XCOM the ability to sign off on and make the decisions on those letters and that legislative activity. And so the goal with this is to just the reason that we've pursued the policy in front of the Board of Trustees, and obviously this is all subject to the approval by the board, is that we would like to have some nimbleness in our ability to respond when there is like legislative changes, especially since so much of funding and funding issues can move kind of quickly. So we want to have the ability to do that without having to get on the 1 of 4 meetings of the Board of Trustees. And then that's all the suggestion, why we suggested having XCOM have that authority, that delegated authority, was again to have that ability to have nimbleness. We only meet a certain number of times per year. XCOM meets more frequently. And so that's the, my kind of high level explanation of the suggestion here. And I just wanted to open it up, see if folks have questions, if we can discuss this and see what the thoughts are on it. Patience?
I think this is a great idea. I think the fact that we de facto did this, or you all did, those of you who are involved in the response to the post-inauguration, the anticipated post-inauguration impact on legal aid. I mean, it has made a real difference for clients all across the state, and you're all to be congratulated for understanding that that was going to be a problem and for acting on it quickly and effectively. And I just hat is off to you guys. So I would love to see this sort of codified. That makes a lot of sense to me. There are just a couple of little niggling questions that are probably a matter of drafting, and I raise them with trepidation because this is potentially weeds. So feel free to say, patient, shut up if that's necessary. I'm looking at the last paragraph, which is kind of the substantive change that you're proposing on page 5. The legislation relating to the following: administration of interest on lawyer trust accounts, et cetera. I'm not clear whether administration applies to all of those following items, and therefore the potential of the executive committee to advocate is limited to administration, or does it include seeking more grant funds, for example? So I don't know if administration is broad enough, or if there's a drafting tweak that could clarify and effectively expand the authority that's been granted. Later, kind of middle of the paragraph, the Trust Fund Commission shall provide advance notice to the State Bar's legislative director. Doesn't say how much advance notice. It seems like one of those things that could potentially, it happens that people decide to have turf wars about really imponderably minor whatever. So I can imagine that we give them notice, we're going to do this, and somebody gets a wild hair and no, you can't do that. Or you didn't give me enough notice and I didn't have whatever. So the clearer it is, the less likely all that is to happen. Similarly, with the legislative director providing that determination prior to the meeting of the Legal Services Trust Fund Commission. What happens if there is no response, or if the response is untimely? I don't know. I don't know. So those are just little glitchy things, and maybe this is good enough as a concept, and maybe you want to take out maybe you want to put in separate advance notice, and then you get an approval. You want to say something like the Service Trust Fund will collaborate with the legislative director, or something completely vague that doesn't, where no matter what, we'll be able to say, hey, we talked to you and we advised you and we listened to you, and keep ourselves out of trouble that way. Anyway, bottom line, great idea. Really important to carry it forward. Don't let these little niggly things keep you from taking it forward. And thank you for your work and your idea and your understanding this needed to happen. So,
Erica, can I quickly respond to Patience, if that's okay?
Please.
So the attachment that's part of your materials, that's already actually been posted as part of the board. The board is meeting literally Erica's on deck right now. Either they're going to meet about this agenda item tomorrow afternoon or first thing on Friday. So it's already been posted, and it's something both Erica and I have worked really closely with executive staff to kind of iron out the details. So one thing that we'll share with you in terms of, and I don't think this is going to be a concern, because what we have kind of landed on is once the agenda item goes to the executive committee, there will be a memo that I will draft along with the staff and with the chairs to kind of present whatever it is the legislation or the policy that the executive committee will consider. That memo itself, I will share it with the legislative director and executive staff and they know that we have a posting deadline. They will not miss our posting deadline, and they will give us a response back before we have to post. So I think that should happen all really seamlessly. And aside from that, what Erica and I are planning to do, along with kind of executive staff at the State Bar, is really have like really ongoing, continuous conversations. And the thing is, we want to be coordinated, right? We're all one State Bar. Part of the overall policy, and I'm sure you guys all know, the State Bar has many sub-entities. The Trust Fund Commission isn't just one. And they want to be able to speak with kind of one voice. So there will be a lot of coordination kind of outside these notice meetings to kind of position ourselves, provide us advice. I don't anticipate really, and plus, our advocacy is something that's like, I think is pretty non-controversial. We are advocating for additional funding under the purview of the Trust Fund Commission. Never, even when we've taken it to the Trust Board of Trustees, there has never been any concerns, any modification. This is just making sure that the commission is exercising kind of discretion under its statutory purview. And this lays out something that's a little bit more clear, a little bit more defined, gives it some structure. And I think it's a really great suggestion to have it go through XCOM. So it has a little bit more vetting. It's at a publicly noticed meeting so that members of the public, our grantees, can come and provide opinions. So it gives it a little bit more formality that's like, I think, good kind of overall.
Angie?
I'm not sure I understand. Currently, I understand that we have to ask the Board of Trustees to be allowed to present advocacy statements to the legislature. Is that?
Yes. Right now, currently, the commission could not like advocate independently before there's approval from the board. So what's going
And I absolutely agree with Patience that the change is good. But will it just go from XCOM directly to the legislature? Does the commission get any say, any part, at least poll the members whether we agree with the position? I mean, I'm sure we would, but
that's all up to you. If you don't want it to or don't agree that it should go to executive committee, you don't need to delegate authority, and it can come back to the commission.
No, I don't mean to take it away entirely. Yeah. It's just that it's some connection between the XCOM and the rest of the commission.
Mm-hmm. And that's all for you to decide. But I will say that the board, it's two separate things. We are preemptively anticipating, hopefully, the board will approve it. So it's subject, and you'll see the motion. That's why this delegation of authority, if you all decide to do it, is really subject to the board approving even the delegation, even giving the commission authority to do it. So we're doing a little bit out of order because for the next time the commission meets is a few months, and we didn't want to miss this cycle to do legislative advocacy. That's why we're preemptively bringing to you a motion. And I'm sorry, that's why there's some confusion. So what's not on the table is like, I think, a revision to the board policy itself. What is on the table is in contemplation of that board passing that motion, whether you all want to retain that authority as a commission fully or delegate that to the executive committee.
Aaron?
Yeah, my comment is along the same lines as Angie's. I'm wondering if there's a way I generally support this idea in concept and completely understand the need to delegate authority to the executive committee, given how quickly things can move during the legislative cycle and the need to be nimble. And we only meet, really during the bulk of the legislative cycle twice in February and May. So I completely understand needing to act more quickly than that. But I'm wondering if there's a way to maybe do a little bit of both, like Angie was saying, like draft the delegation of authority to say, in the event the full commission is unable to meet and act in a timely manner, then the authority is delegated, or something along those lines. And then also to build in, I'm assuming you would do this anyway, but maybe just to build it in, a report back. You're going to be reporting to the State Bar on all the positions that you're taken, and this would be really the executive committee on the commission's behalf. Obviously the full commission would like a similar report back.
Catherine? And then I'll address kind of everybody's comments.
Just with that discussion, I think I heard Angie in some ways in addition to a report back, also saying, is there a way to alert the commission members that the executive committee is going to decide something? And here's the memo on that. And that way, if a commission member wanted to attend that meeting and provide a comment about it, they could do that. So that's, I think, what I heard Angie suggesting, which seemed pretty reasonable to me, of just making sure that everybody understood what was happening, as sort of a loop back during the process and at the end.
You know, so what I can do, based on that statement is, you know, when we go to post the materials for the executive committee, that it'll have a nice memo and then a chart with like what it is.
Yeah.
We'll just send it to you all.
Exactly.
FYI, and then we would build into our process anyways, Erin, as part of like the executive committee. Like this is important, right? That would be part of the chair's report. But again, we will definitely build that in. But I think maybe the memo will take care of the formality, and then we'll still build in the oral report. So
Yeah.
that you have an opportunity to come and participate in the conversation.
My other question is on this, which I think could kind of both make sure there's mission input, but still provide the nimbleness that we're thinking of is, you know, we have our kind of in-person meeting, and I think there's a way in which we could, at that in-person meeting, sort of have like a legislative priorities or thinking, you know, kind of discussion where the commission as a whole could provide like its input on like what are its priorities, what are the things, you know, its guidelines, what are some parameters that it would like to put into place with regard to legislative action, so that the executive committee, if things are coming up in a more urgent fashion, are working potentially within those parameters that the full commission has, you know, discussed and adopted. Or, you know, because I take the point, right? You know, we want to have the nimbleness to respond when we need to, but obviously, you know, the full commission wants to have the ability to participate. And I think, you know, Dewan's suggestion of giving everybody the opportunity to like, you know, here's what's going on at XCOM, you're aware of it, you can come and attend, but more generally having that at the beginning of the year, you know, discussion where we sort of set, I mean, I should also say, assuming it gets approved by the board of trustees, it's not a very broad space that we can operate in autonomously. So I just want to flag that this is about basically advocating for funds and especially in this environment, probably defensively protecting funds as much as advocating for new funds. And that's why we want to have that nimbleness. But that doesn't mean that we can't have other legislative, like discussions about other legislative issues that we don't have autonomy on, that we would want to advocate, you know, that the Board of Trustees pursue or recommend to the Board of Trustees. So more generally, I think it'd be great if in that in that February meeting, you know, we have this conversation where we say, here are the things that, you know, we as a commission want to pursue in the next year or so, you know, here's the legislative pieces we're thinking about. Here's any particular threats, you know, these are the areas in which the XCOM can move. So that's just another suggestion as a way to make sure we're both getting everybody's input, but also having the nimbleness as necessary. And of course, reporting out to the commission every time.
Yeah, thank you, Erica. I really like that idea as a way to, at that key legislative moment of February, to kind of get a sense of what's going on this year and what opportunities might be coming up and what does the full commission think about that. I certainly appreciate the invitation to attend more meetings. I may not speak only for myself when I say it can be quite difficult to fit additional meetings into your schedule to try to jump into all the XCOM meetings. So if there is a way to work it into a full commission meeting, just to get input and kind of pressure test some of the positions that may be coming up, I think that would be great.
The questions. I guess my question then is are people willing to motion to have the delegation? Do we need to adjust the resolution in any way based on our discussion?
I move approval.
Chris, could you flash the motions just so everybody's comfortable?
Yeah, let me share my screen just one moment. Can you see the screen now?
It's loading, Chris.
Okay.
Here you go.
I'm going to scroll down just a little bit to make it a little more. There you go.
So is that the only we're not doing a delegation motion today, right?
The resolution in the memo would delegate authority to XCOM.
I see. Okay, thank you. Sorry, it was small. I just
Oh
saw
yeah, it's always hard to tell. I have a big monitor, so I'm gonna just
now
zoom
I
in.
have a little tiny one. Thank you. Thanks so much. So you're not asking, so this is really just the delegation if they pass it, and you're
Yeah.
not asking the commission to vote on the concept that's going to the Board of Trustees.
No, because
No,
the concept is under, that's the board, the board's, autonomy. So
No,
we're,
I know it's that. It would be like, does the commission support the
Mhm.
concept? Like, so Erica could say the commission, this isn't just, this is the commission recommending it. That's, I guess, what I was thinking.
I mean, I'm not opposed to adding, unless there's some conflict, I'm not opposed to adding like a second resolve that's assuming that we have support for it, that the commission supports the proposed resolution before the Board of Trustees. It sounds like that's what folks, feel. And that would be, I think, a powerful to be able to say tomorrow.
Yeah. So Chris, could you put a further resolved?
Yeah, I'm gonna do it in track changes just in case we decide to take it back.
So maybe further resolved that the trust fund committee supports in concept the proposed revisions to the guiding principles.
Yeah. And actually, while you're doing that, I did want to know you addressed patient's question. But I did just want to just add a couple follow-ups as far as kind of the what ifs. We sort of tried to, in negotiations with exec staff, try to build some of that in. That's why there's like an appeals process, the Board of Trustees. If there's disagreement about whether a particular position of the question, if our view is that it doesn't affect the general fund, but the legislative director's views that it does. We also tried to build in the timing factor. So the thought was, because the legislative policies and proposals would go through either the Trust Fund Commission or a committee to, and here we're thinking of tax, there would be those are public meetings, so that was put out, then that would be the time to provide notice to the legislative director. We obviously would do our best to give them as far advance notice as we could, but at least.
Eric, I think you're cutting in and out. I'm not sure if that's just my internet, but I think you're cutting in and out.
No, it's mine. Sorry, I could briefly. All I was saying is just to build in time with the meeting and having the agenda and then having the approval. Anyway, that's just to try to address some of patients' comments.
So I apologize. I wasn't sure if that was a suggestion to update the resolution because Erica cut out for a moment, or if that was a more global comment.
Does this work though for the further resolve? Does this kind of address?
Should we call them legislative guiding principles? Isn't it in the context of legislation, state bar legislative program?
Yeah.
Like
Thank you,
not just
Catherine.
general guiding principles.
Yeah.
Yes. I think that's important too.
And then just while that's happening, I think there's a consensus around the process pieces of people are going to get notice of an EC meeting. They can choose to come or not, depending on their schedules, etc. And these other ideas about how to engage the commission. I don't feel like they have to be part of the delegation, but other people expressed that view. So I, like Angie and others that said that, do you want us to amend the resolution, or is it okay that there's a common sense of what's going to happen and you're okay with that?
And I think what I was hearing is we'll just pursue kind of all avenues. It'll be built into the February kind of planning session. We'll also send out the memo when we post for the executive committee, and we will do the oral report at the
Yeah,
commission meeting.
those three components, I agree with that. Which is kind of the process to implement the delegation in some ways, I guess, and just confirming for that kind of a process piece that's not part of the resolution is okay.
Angie, your patience, does that feel comfortable for you? In terms of the motion, I don't think it's necessary, but if it, yeah, okay.
That's fine.
Okay, so with
I will
the
make a
further,
motion to approve the revised resolution.
great, we have a second.
I'll second it.
Oh, thanks, Angie.
All right, I'll do roll call vote. Alikani, Babcock,
Yes.
Blakemore,
Yes.
Campbell,
Yes.
Falcon, Gonzalez,
Yes.
Huang, King,
Yes.
Judge Klein, Mahoney,
Yes.
Morales, Pryor,
Yes.
Judge Rosie, Sandville,
Yes.
Smith,
Yes.
Stalker,
Yes.
Vargas,
Yes.
Escobedo, Milrod,
Yes.
Balsarov, Connolly.
Yes.
All right, so that's 13 yeses, 0 nos. Motion passes.
Great, thank
This
you
is
all.
Cliff
And
Klein. My screen was blacked. I was trying to get to my unmute, so I'm a yes.
Okay, so I'll revise that. That's 14 yeses for this motion.
thank you, Judge Klein. So I think I'll just note, this will be up at the Board of Trustees tomorrow. It's either going to go tomorrow afternoon or Friday morning. Obviously, if anyone wants to tune in and, listen in, please feel free, and, we'll see what the Board of Trustees does with our suggestion. Great. Okay, I think our last bit, and I'm sorry, I have to plug in. I apologize a little bit on the angle. Is the discussion regarding strategies to support grantees, which is Chris.
Thank you. And I'm going to start my slides and share my screen. Okay, am I successfully sharing my slides? Thank you. Great. Well, I'm honored to be able to maybe be the one to close out the meeting with what I hope will be a sort of fun and interesting and generative brainstorming type conversation about how the commission and also State Bar staff can continue to support grantees in a rapidly changing world. We think that there's just it's important to keep checking in over and over again and pivot at the frequency that grantees are having to pivot to stay current in our support for them. I wanted to start just to kind of bring it home as a framing moment, because everything kind of comes back to this Legal Services Trust Fund Commission strategic plan, its implementation plan, the goals that are sort of built into it. So I'm just going to read this kind of quickly, but I'm more than happy to like tab back to this at any point during this generative conversation so we can keep bringing it home. But the first strategy is for the commission, as 5-year strategic plan, is to increase access to legal aid to advance the commission's mission. Strategy number 2 is to increase access to legal aid by serving communities more efficiently and effectively. So that is something that I'm going to have a couple of discussion questions around, is how we can keep supporting grantees to be able to use commission resources efficiently, reduce burdens on them, et cetera. Strategy number 3 is to increase access to legal aid through greater accountability, transparency, and visibility. I'm going to have at least one discussion question for the commission to brainstorm around communications, which I think it's at visibility. Strategy number 4 is to increase access to legal aid through greater collaboration and coordination with a diverse range of voices, where I'm going to ask you about, I'm going to run some ideas by you that might enhance collaboration coordination. And strategy number 5 is to increase access to legal aid through new opportunities to enhance commission impact. And I have some ideas that I hope will generate a discussion around how to increase funding for legal aid and similar opportunities. Before I get to some ideas we wanted to put in front of you for, kind of on the spot feedback, reactions, and some generative thinking. I wanted to start with some of the things we're already doing. It gives you a nice sense of sort of like what types of support seem to be sticking. We're getting positive feedback about it. We can sort of refine and iterate on these exact interventions, or we can come up with new things that are similar. So these are just examples. We're doing quite a bit more than what's on the next couple of slides. But for an example, since the commission adopted its current strategic plan, we have launched at least 2 very important initiatives to support grantees. One we just call the Training and Technical Assistance Initiative. Its goal is to give grantees, and to be responsive to what they tell us they would like to receive, but to give them more proactive support to be as strategic as possible with their use of commission grants, as opposed to what we used to emphasize in the past, which might be like, we're going to release an RFP, so we'll have a webinar to walk you through the RFP. This is more skills building and knowledge building and facilitating peer support. It mixes trainings, panels, convenings, and written resources like guides. Since we launched this a little less than a year ago, we've had 10 events. Again, this is exclusive of our more normal webinars. These are more proactive things. 10 events or panels or roundtables or guides. We have 15 more proposed and in development. And to give you a sense of what sort of topics these feature, they're things like, we did a training on how to manage federally funded grants, like how to comply with the Code of Federal Regulations that apply to those funds. How to do multi-year budgeting strategically, and then these are cross-grant and grant-specific. So a grant-specific one, we've done 2 panels for public defenders and qualified legal services projects that represent respondents in care court. We've had a college FIG grant-specific roundtable. We've done a written guide on how to prepare for state bar site visits, and there's a lot of others. The legal tech initiative is another initiative that is supporting grantees. It's more recent. It supports their use of emerging technology, including generative AI, to be able to deliver access to civil justice safely and responsibly and at scale. It is following a very rigorous report that the State Bar Commission with Harbor Labs that Judge Rossi mentioned earlier, and that we plan to circulate to the full commission after this meeting, that studied this commission's grantees' legal tech needs, like what they said they needed. And one of the first interventions for that initiative is staff is planning monthly peer support workshops that grantees can be the ones to demonstrate for their peers how they're using legal tech to deliver legal aid responsibly. You've heard about this quite a bit, so I won't go into too much detail here, but we've had multiple interventions to support grantees and what we're calling a rapidly changing federal and state policy landscape, things that have happened over the last few months. The world is changing faster than ever, helping meet their needs and answer their questions. This has included surveys, multiple convenings in person. Some of the recommendations that came out of that data gathering is after conferring with grantees, the State Bar has, and there's a lot of this was done in coordination with LAC. We've recommended prioritizing multi-year flexible funding so legal aid can respond to crises and offset the loss of funds, especially if they lose federal funds, helping legal aid to modify delivery models through legal tech and strategic community partnerships, establishing dedicated funds for this commission. And this is actually something I'm going to ask about when I put up my discussion questions, to rapidly respond to emerging legal services needs, sort of like the nimble piece, providing funding to legal aid serving rural Californians who are disproportionately underserved, and increasing legal aid attorneys in rural California, supporting legal aid recruitment and retention, including multi-year postgraduate fellowships. We've convened EDs and other leaders, grantee leaders in LA and San Francisco to facilitate peer support. They sat on panels and gave trainings to one another. This kind of came up earlier. Another example of this sort of like changing landscape support is we've issued we've endeavored to support grantees on more high stakes, complex potential changes to policies, like if the federal government were to revoke grantees' 501c3 status, what would that mean for their eligibility for commission funding? And the guidance we have issued to them is that based on the IOLTA statute and State Bar rules, that particular change in their 501c3 status would not jeopardize their status as a nonprofit incorporated in California, so they could still apply for IOLTA grants. Okay, last slide with examples. Again, this is just to kind of get you starting to think about this. We have also increased support for disaster legal services. This was somewhat timed with the extremely devastating wildfires in Southern California, but we were doing a lot of disaster legal services work before that, but we really ramped up. This includes support for the Disaster Legal Assistance Collaborative. We've created a fact sheet on disaster legal services. We've advocated for dedicated disaster legal services funds, as well as increasing grantees' ability to use their IOLTA funds on disaster legal services, so that if a Californian is directly impacted by an official disaster, maybe their income can be a bit higher than 200% of the federal poverty threshold, and they could still receive IOLTA-funded legal aid. Programs could support one another with their funding that was for a particular county if the program is in a different county, what we would normally call out-of-county spending, without incurring the penalty that usually comes with that after an official disaster, if it's disaster recovery. And we've been promoting the California Pro Bono portal. And we're doing ongoing work. I just like to kind of shout out to the California Access to Justice Commission and LAC for being our co-leaders in this space, continuing to convene other state agencies to get them to partner with legal aid. It's more important than ever. We had 17 agencies attend a convening in the fall about this topic, and several of them are now sitting on a working group that Cal, ATJ, LAC, and the State Bar continue to convene to kind of build out what I'm just calling the infrastructure for state partnerships with legal aid, like best practices and a directory and the like. I was just going to pause real quick. Does Dwan, does anyone else want to provide any other examples or clarify anything before I start the discussion piece? Great. Okay. So we really wanted to end today's meeting with a sort of fun, generative brainstorming type conversation where you can just share your like top of mind thoughts or your extremely thought out and evaluated long-term thoughts with State Bar staff. We're going to write them down. We're going to assess them. We're going to see how we can incorporate them into our ever evolving schema for supporting grantees. And I might also ask for ideas and pitch a few ideas on how like you as commissioners might like to also get involved in supporting grantees. But it can also just be things like, hey, I think State Bar staff should do this. So this slide has 4 topics. I have another slide after this one that has another 4 topics, and I thought we'd just tackle them in chunks of 4 at a time. I'm going to start with the one on the left, and I'll let it sit for a moment and see. I'm going to pitch like an idea that's in that space, but we can always just kind of come back to things as ideas come to you. So in no particular order, I actually kind of want to start with the second one here. I thought this would be sort of like a really interesting lay the foundation one, and that's the hearing from grantees. I'm going to come back to communicating about grantees in a second, but the hearing from grantees. So far this calendar year, it just so happens that staff has mostly been able to share kind of as recent as possible updates about what grantees' ever shifting priorities and needs are at committee meetings and commission meetings after we've administered surveys or met with them in focus groups or convenings. We've kind of come back and reported back to you on what we've learned. And we were very lucky, I think, to have some commissioners actually attend some of the in-person convenings, so they got to hear it firsthand. And in the spirit of hearing from grantees firsthand, I wanted to run the idea by you of are there other ways the commission would like to hear from grantees, for example, perhaps directly? Like, how would the commission feel about something like having listening sessions with grantees at the regional level? Like we can make sure the regions are big enough that there'd be multiple grantees who could participate, but here's what this region of California's grantees are saying, and we can set those up for you and you can hear from them directly. And I want to go even one step further, because this is to demonstrate this is truly a blue sky conversation. What about having like traveling listening sessions where maybe you even get to meet with some of them in person in the community? And I'm just going to let that one sit and just see what people's reactions are to that.
Well, I'm not going to let you let it sit too long. I love this idea. There are, I have thoughts, especially about identifying more of the third bar here, but it's been 3 years since I quit my job as the executive director. So there may be new and different needs in the program now. And so I think it's really important. And I know when I was an executive director, this body was extremely far away, and I was not at all clear that there was any. Our communication was through staff, and that's at an implementation level, not at a conceptual policy level. So I think that's a really wise idea, and it would be fun too.
Yeah, Catherine.
So I think it's a really interesting idea, and I guess to put the work into it, I think there has to be a sufficient number of commission members that would be willing to participate in the discussions. And I guess I was reflecting back on one of the first things that Erica said, Erica Connolly, about the challenges staff have to getting us all to meetings and other things we say we want to do. So I'm interested. I like hearing from grantees. One of the things when I very first came on the commission was that at commission meetings, we had kind of presentations by grantees about what their work was and the opportunity for discussion. The challenge with that was that we often ran out of time and we told people then they had 2 minutes, which isn't really a discussion. So I'm kind of interested in that model as well, but with the understanding that we would block off a sufficient amount of time at every other meeting or something to hear from grantees, like, several of them, and have sort of a set of questions that they would know about in advance, and we could benefit, like, what are they doing? What are the challenges they face? What are the ways the commission could be more helpful, right? Anyway, something like that. So I think there's sort of different approaches if there's an interest in hearing from grantees.
Thank you, Catherine. Kenneth.
Yeah, I think it's a really interesting idea, and I think Catherine's idea of having some grantees present probably at commission meetings is a really interesting idea and a way to deal with what I would assume would be Bagley-Keene concerns if you had a number of us meeting in regional listening sessions with grantees. I would think you could only have 2 commissioners as part of those listening sessions. Otherwise, you would probably have a Bagley-Keene problem, I would think. Maybe not. But the one thing I want to make sure we made sure that grantees understood was that this wasn't a site visit, that this, which they would look at very differently from a listening session. And that it really is a listening session where we want to hear from them as opposed to having them answer specific questions that we have as part of a site visit.
Thank you, Ken. Erica.
Thanks. So I hear the Bagley-Keene issues, and I think it's great to have the organizations come and present, because it's a great opportunity for them to highlight their work. I will say, having gone to a couple of the convenings with the, and sat at the tables with the organizations, I do think, and maybe this is something where you just deploy 1 or 2 commissioners at a time, I do think I got more candor about some of the issues they were facing, problems that were coming up, than maybe everyone would feel comfortable doing in a publicly recorded meeting, right? And there's a way in which, someone can tell me some issue that they're facing, and maybe it's just more because it's just casual conversation, that then I can anonymize, but it's still an issue that we can address. But if they have to get up in the meeting and say, cities don't understand and are trying to cut our funding, or we're struggling with this agency or that agency, it just can be really, I just think there's an opportunity potentially to have a little more, to deploy us in sort of 1 or 2 like working groups to kind of have those opportunities talking, that maybe just like you might just get more candor. That's all I'm suggesting on it. And again, I agree with Catherine that like that requires that there's like enough people to do it. Like I know I don't have the time to go traveling around the entire state with like 1 meetings, every other week, but I just encourage, I think this is a great way to interact with our organizations and hear from them in a little bit, more of a candor setting. Ken, I don't know, your hand's up. Maybe I said something that sparked your interest.
Yeah, no, so I think you're right, Erica, that I think people will be more candid in a small group setting like that, as opposed to making a presentation in a large publicly noticed meeting. Am I right that there would be a Bagley-Keene problem if more than 2 of us were at one of these listening sessions, that we would have to notice it and deal with all the Bagley-Keene issues?
It's not the 2. 2 is what Brady has said to, that we would never hit kind of quorum. But if it's like 3, but we don't constitute a quorum of any of the committees, then that would be fine. So it's not necessarily the 2 number, but
like 2 is always
eye.
safe, but yeah.
Yeah.
Got it. But it's still a small number.
Yeah, it's still a small number.
Whether it's 2 or 3,
Yes,
it's still a small number. Okay, got it.
Yeah, once you hit a quorum of like the commission, then now you're on the record, it's recorded, it's like
I mean, I think in some ways, like we used to do, I don't even know, because I haven't been on eligibility, budget, and review, but we used to do those, like the eligibility review meetings. Oh my gosh, what were they called? ERCs?
Eligibility Review Conference, yeah.
Yes. And those were another, I thought, opportunity where you'd get a couple of commissioners, they'd meet with the organization. Usually that was because there was like some issue going on. But it was also a really like interesting opportunity to learn about what were the issues going on with a particular organization. So, I think, and also if you're only deploying like 2 at a time, maybe you don't need all of us to commit to traveling to Fresno, right? Or to San Diego or to Sacramento. We can kind of use people strategically. So anyway, I'm just saying, I think this is like a really cool idea. I also think presentations where we can allocate time where they can come and present to us is also a great opportunity. I think it's great to communicate publicly about what the organizations are doing. So those are my 2 cents on this.
And it occurred to me there's some of the commissioners are spread across the state. Like I think Jason is in Riverside County, so he might be the one to do a SoCal one or something. And then I do have as one of the topics reducing burden. So I'm really hesitant to suggest something that would be a burden on grantees. But I was like, oh, it would be, I don't think, anyone would require it, but the thought had occurred to me like, oh, what if we invited every year the new grantees? I think Dawn said maybe there was like 5 or 6 new applicants we've never had before. If they get this would not be an ERC, but like if they are approved for an award at some point in the fall at their convenience to like come and talk about the work they do optionally, like they don't have to do it, but like, and highlight the new grantee or something.
Although new grantees are less likely to have an idea how the commission might be able to help them.
That's true. Yes, that's true. Good point.
No, I love the idea of small delegations of commissioners. It doesn't need to be the whole body. I think we'd learn a lot, and then we'd get report backs from whoever went out to the programs. I think it'd be really helpful to us, and I think it would be very reassuring to the programs to know that we are interested in hearing from them.
Wonderful, thank you, Patience. Well, I'm going to move on to the next one, but we can. Oh, Erica, I was going to say we can come back and talk about any of these ideas as much as we like.
I actually, I'm sorry, I'm going to transition you to one of the topics that I wanted to just ask about.
Oh yeah.
Which is, you mentioned reducing burden. And I wanted to just bring us to that because like, I've been on the rules committee for a little while now, worked on different rules. I'm curious whether we've gotten feedback or whether we intend to get any feedback about how our codification process, like what the impact has been on the organizations from the various rules, because some of the rules were just codifying practices we already did. Others, we've like changed the practices. And I'm just curious if there has been any kind of inquiry about, has it improved things? Are we generally improving things on burden? Are we increasing burden? So you may have that information, but I didn't know.
Only anecdotally, Erica, but we haven't done like a systemic way to like get feedback overall or try to gather that, in which we can, but only anecdotally. And it's honestly been mixed. I think it's more because our memos are very long and like programs reach out because they need more guidance. And so Chris has really done a great job as part of his launching his technical assistance to kind of coordinate touch points so that we can go over the new rules and give guidance. And then, there's going to be that grantee handbook that's going to be coming at some point that will then, but only in that context, honestly. So.
Yeah. Okay. I'm curious that I won't take you too far off of your points on the reducing burden, but it was just having passed a lot of rules now, we talk about, burdens and stuff, but I'm not, it might be something to think about is having some kind of scheduled follow-up, right? Where we do like a check-in after we pass certain rules to see what the reaction is. I don't know, just one thought.
Thank you, Erica. And Patience, we can actually take these in any order you like. So we can just move on to reducing burdens. And out of Patience, you might be raising your hand about that one.
Thank you. So prosaic, tedious, and for us, really frustrating when I was running a grantee organization were the reporting obligations and the fact we kind of had to invent our own systems for figuring out how to do the reporting. I remember when we got a Schreiber grant, oh my God, we had to pay for a bridge software so we could communicate with the mothership of the data collection thing, and every single questionnaire took 45 minutes. Obviously that wasn't an IOLTA grant, it wasn't this organization, but those kinds of challenges are not uncommon. There are also the perennial, like our IOLTA application was always due within 20 minutes of our LSC application. And it wasn't like we could send IOLTA, the LSC, which was, it wasn't that they were that different, but they were different enough. So that kind of attention to the daily, the complexities and the daily difficulties of meeting the requirements. Not that the requirements aren't legitimate, but like, is there a way to streamline this? I can imagine that there are. I don't know. I understand Smart Simple exists. We found it neither smart nor simple when I was, when we were trying to grapple with it. So it's not that nobody's tried to do this. So there have been efforts, and I recognize that. But this is one of the ways I think that in-depth conversations with grantees would be really helpful, and would give some guidance. Because I don't know whether the current ED has a problem with this, but we sure did when I was there, and my development director, regularly was pulling our hair out by the roots. So, so the technology, the forms, the attention to what data do we really need to collect, and what's a streamlined way to do that, like all of those questions, I think are really important, and that would materially reduce the burden for the grantees. They could spend time providing legal services instead of filling out forms and stuff.
Mm-hmm. And I think the data working group, well, the PDI committee has in its charter looking at whether and how to reduce burdens on grantees when they report. And the PDI committee has 2 commissioners sitting on the advisory group for the data project. So I don't know, what the outcome, what those recommendations will end up being, but grantees get to sit on that too. But that's a perfect example of like, maybe there's a there for reducing burdens on grantees when they report, because they report on every funding resource they receive through the commission, and that that reporting framework, the Equal Access Fund reporting framework, might mean very similar reporting across all those funding sources and the like. So what occurred to me is that I think it's really wonderful that the advisory group for the data project is likely to look at that, burdens on grantees when reporting. And it occurred to me, like, should we be looking at ways to reduce burdens on grantees when they submit applications, when they request budget modifications? Currently, they don't have to request budget modifications if it's at 10% or less of their total award, which is a wonderful way to avoid a burden. But then there's the other cutoffs when they maybe request to carry forward funds and the like. Yeah, Crystal, obviously I was talking about your project.
Sure, I'll just chime in a little bit. Thank you, Patience, for your comments. Yeah, so reducing burden is really one of the sort of the pillars, that the driving forces for the Legal Aid Data Project. We're considering sort of all aspects of not just reporting, but as Chris mentioned, the application process and what efficiencies and ways to streamline would be beneficial. We're quite a ways away from making a recommendation, but all of sort of that grant making process is sort of under consideration, because we know that all the information sort of feeds and talks to each other. And I think we've and the working group has identified that there are definitely opportunities to hopefully make things a little bit easier for grantees.
Did by chance any of our commissioners who were EDs of grantee organizations, did you find the applications for competitive or the formula grants? Because IOLTA and EAF is like your threshold grant. And then once you get those, you can apply for all the discretionary grants, the applications, maybe the budget modification request process, or the process to carry forward funds. Do you happen to recall if that felt like there were maybe some unnecessary burdens or inefficiencies? It's totally fine if you would need to think about that.
I'm going to just speak to the timeline for getting things done, which is, Dwan, or maybe you reported earlier, like you have to complete the application within 30 days, and you have to come after it's released, and you have to complete your budget after that. It's a large organization that provides direct services in all 58 counties. Saying you're going to do that in 30 days is really quite a lift. And just having a bit more time, I think I don't even know if that's possible, but I felt like people were not sympathetic to our struggles to get and we were always on time, but it, to Patient's point, was a heavy lift to get that done in 30 days, both of those. You have to do a budget for 58 counties.
Yeah, that's for IOLTA and EAF. Yeah.
Yes, I mean, that's not insignificant work, and that's after you have the data to, you have to exclude certain kinds of things when you're doing your qualified expenditures and figure out then what is in every county. And I mean, I think at some point it's worth our staff, because this isn't really a commission thing, sort of having those conversations with grantees like that do work in all the counties about what their process has to look like to be able to get accurate information to people on time.
Thank you. Ken?
I will tell you, as a former single county grantee, it's not that less difficult for a single county grantee, particularly now that you're dealing with the amounts of money that you're dealing with and multi-year grants. And so I do think thinking of ways to expand that window so people have more time to create budgets would be helpful. I also think while it's much better now than it was, say, 10, 15, 20 years ago, it is still a frustrating process to go through the application process and the budget, particularly the budget process, and have IOLTA and EAF right next to each other on the page, but you're creating different budgets for them. It would be immensely easier if the EAF money were put in the pool with the IOLTA money and was treated like the IOLTA money, as opposed to having to identify discernible sets of activities that you use your EAF money for, whereas your IOLTA money, you can use it more as general operating funds as long as it's for eligible services for eligible clients. I think that would be a huge decrease in burden on programs if they didn't have to think of EAF separately from IOLTA.
I think that's a really good point, Ken. And I know you and I had talked kind of extensively about that EF requirement. And I mean, it's not a statutory requirement. However, there is an expectation from the Judicial Council that has been communicated with the legislature. So I don't think we need for that change, like a statutory change, but we do need to interface with the legislature to make sure that they're comfortable. And, perhaps it's not too late this year to even pursue that, but maybe like Chris and Judge Rosie and Ken, we can talk to you about it offline as part of the PDI. So I mean, these are the type of ideas that would be helpful for us so that we can workshop and see what's kind of tenable either this year or next year.
And again, this is the kind of thing that current grantees will have something to say to you. I remember we got, I don't know, 27 cents to serve Mariposa County. I mean, seriously, it wasn't 27 cents, but it was like nothing. And we had to figure out what the heck are we going to do there? And our staff travel time to the county, was going to essentially eat it up. I mean, it worked out not to be truly useful to people in the county, and it was very difficult from our point of view to figure out something that would be worth the money. That would, we ended up subsidizing our Mariposa County. I don't remember how we did it, but it was very frustrating and a little bit. And the rules are what they are, and we respected them, but it was crazy making.
I think you can give it back. I don't think you have to accept money from a county.
Well, that's what we should have done probably, but we didn't do that. So we tried to work with what we had.
And then I just wanted to say, I also jotted down from earlier in the meeting, Aaron had made a suggestion about exploring if there's any flexibility more structurally or systematically with the audit deadline. I know that the commission and staff needs audited figures when we get to the point where we need to know for sure what the qualified expenditures are, and that's, but like if maybe the process or the timeline or something could be different, I jotted that down in the notes as something to explore.
Thanks, Chris.
Erica.
Thanks, Chris. So this is, I might be transitioning you again, but it is related to burden. So one thing I think I also wanted to just raise is, and this I think also relates to your first one about communicating about grantees, is I feel like where we've been able to get information about the results arising from our grants, those have really turned into like really powerful reports and messages and infographics that I think can be really strong when we advocate for keeping our money, our grant money, or advocating for more grant money. But I also know that can be a lot for the organizations to comply with, right? To have to not only go through the application, go through the budget, make sure they complied with the budget, but then try to report out, especially, correct me if I'm wrong, but I don't think we collect that kind of data on IOLTA funds, right? We don't have a report in about everyone that they serve with IOLTA funds or anything like that. I know we do sort of how they deploy the money in qualified expenditures, but not like hard numbers. But I just want to flag, I do think that helps with telling the story about the grantees. Like we can tell like sort of very specific stories and highlight particular ones, but having at a big level, when Dwan and I went to the Judicial Council, we had like really great data where we could say like, this is how many people the homelessness prevention grant served. This is how many people, care courts served. And then also getting sort of anecdotes, where there were specific discussions about a particular client or a particular kind of thing. So I wonder if there's a way in which we can like partner with the organizations to get that information, because it can help us with advocating for those funds, without overly burdening them in the process to make it too difficult. And so I'm not really providing any solutions, and I'm sure that's something everyone's flagging, but I just wanted to raise it as something it's been on my mind, is how we balance those two things.
Great. And if I may, and I see Ken has his hand up, I'd love to actually use this as a good segue for communications about grantees, which was the first topic on the slide. And I did want to point out that our recent communications, like fact sheets about services that grantees are providing in particular areas of law or with particular grants. And we did a at least one, I think we called it like a policy brief on grantees' use of the US DOJ accredited representative program in California, which can expand access to immigration justice. They got a lot of attention from other state agencies. I think they get attention from public policymakers. So there's a really exciting opportunity to do even more communicating about grantees' work and clever like access to justice strategies in a way that's strategic and impactful. So I'd love to hear, but in addition to things like fact sheets about the work that grantees do, if you have other thoughts as to what the communications could look like from the commission and state bar to really like highlight the importance of their work and what they're doing. Ken, I don't know if you were also going to talk about communications or.
Yeah, well, yes, but also about the information, the data from grantees that flows into communication. So I do think those kinds of fact sheets make sense. And I think keeping them short, keeping them issue specific, so you can tailor them to a particular audience is probably going to be more helpful than just generalized numbers, although there are audiences where those generalized numbers are important as well. We do collect information on what people are doing with their IOLTA grants through the major benefits report. Now, having been one of the participants in the working group that created, I will reluctantly admit that I was part of the group that created that report. It's a beast. It's a total beast. And I can't imagine what staff does, I pity the poor staff person or people who have to deal with over 100 of those major benefits reports with all the data that's included on them. But there's a lot of data there in those reports. Also, there was a point in time, and I don't know if you still do this, where, and I think it was in connection with EAF, where you were collecting 1 or 2 or 3 vignettes about case success stories. Well, if you got over 100 grantees and you're collecting every year 2 or 3 vignettes, that's 200 or 300 potential success stories that you could then use in fact sheets, snippets of those success stories, and it's oftentimes those successful anecdotes that can drive public policy.
Thank you, Ken.
I'll just echo on that though, which is as much as data from the grantees is like is really helpful and anecdotes from the grantees is great. I also think going like one of the we had anecdotes from like judges talking about how like the partnership grants were really helpful for like pro se, you know, parties in front of them. So like also talking to other community members about the impact of our grants on them, right? So we, you know, we did like the interagency convening. Are there state agencies that might be willing to like give us a quote, give us an anecdote about the ways in which our grants might be supporting and making it easier for them to help people who are like applying for benefits, that kind of stuff. So just suggesting, because then it feels a little like a third party kind of also not verifying, but like also providing good feedback about what we're doing.
I love that idea. Especially, and that's a nice cross-programming with one of the other initiatives that we work on with Cali, TJ, and LAC, which is trying to get more state agencies to partner with legal aid and how the agency serves Californians, and even maybe like do joint publications with legal aid or fact sheets. Yeah. Wonderful. Other thoughts about the commissions and state bar sort of communication strategies to sort of highlight the important work that the grantees are doing. We love the fact sheets. Before we move on from this one.
The only other question I'll just say is we have these great fact sheets. I think one other thing we should think about is like, how do we deploy them and where do we put them? I've had this mundane suggestion for a while, which is like, we should have a web page that kind of highlights all of this. And I know, and assuming that, you know, this policy passes in front of the Board of Trustees, those fact sheets might be good, you know, attachments to any letters that we do. But yeah, I just want to give some thought to like, are there other stakeholders that we should be more proactively providing those fact sheets to in order to build this? I know there was some talk about kind of public-private partnerships and that being an area that we're like looking into as like, you know, other funding sources may dry up. So I wonder if there's a way in which we can think about who we send that stuff to, whether it's courts or whether it's
I want to,
yeah.
That's just what I was thinking actually, but in a darker way, I guess.
Okay.
We may or may not want to draw attention to some of what we do.
Totally. That's a great point too.
What we've been discussing is data, and most of the data is, you know, evictions or, you know, whatever. I mean, kind of like garden variety, but it was really important to us to do impact work, and we did some major stuff. And so the data collection process doesn't really, it was my experience, it didn't really allow us to take credit for the region changing work that we did. And so that's a little frustrating because it was many staff hours, and we had one client, and we had like at different times, and I put a lot of my time into it, you know, so multiple staff members. And so that's frustrating. And that's something that the data that we were asked to provide didn't really make space for. So I think that's a problem, partly because legal aid exists to change the world, not to just make sure Mrs. Jones doesn't lose her house. So if we're not asking for that data, we're not encouraging programs to do that kind of work. And that's a problem. This is why God made legal aid, basically, was to do this, to do impact work. All of that said, right now, it's going to be dangerous to lift up the impact work that our programs do. So I just really raise this to both encourage us to encourage the programs to do the impact work, figure out what kind of data that would, like, what are we collecting? What would we want to know? But then how we deploy it and who learns about it. I mean, it may be a kind of set of sub rosa conversations with friendly legislators. This is not something we may want to do fact sheets or put on our, at least for another 3.5 years. So just saying.
That's a great point, Patience. Thank you. And just in the interest of time, I might find a way to kind of weave in this fourth topic, but I do want to go to my next slide, which is also my last slide, because it has 4 other categories, and I want to make sure some of them are big, so I just want to make sure we get to talk about them too. Okay, so previous slide was a little bit more sort of like, what we've been doing for a long time now. This slide has a little bit more like of the more recent stuff. So something that we wanted to be sure to get your take on, because we think it's a very exciting opportunity, is with this first box, which gets at funding urgent and emerging needs. Things that might, because the world is changing so quickly now, something might feel secure to a grantee one day and then feel less secure to them the next, based off something that they read about in the news. So there's a lot of processes that are being sped up. So for the commission to be able to stay nimble in supporting grantees and react in responding and protecting them to things that are happening quickly, I wanted to run by you the idea that State Bar staff, in consultation with LAC and others as appropriate, explore with grantees, we can call it a task force or something else, the idea of the commission being able to use certain funding sources that historically have gone out by IOLTA formula, like donations from attorneys. The Business Professions Code has a section 6033, sometimes we call it the 6033 donations, that just go up by IOLTA formula, which means it reaches every grantee in the state, but it can also mean the smallest grantees will only get a very little bit of it, and it's just sort of spread out. An alternative could be, for example, allowing those to go into a pot that the commission can administer to programs that need it very quickly. They could apply for it and say, we're having an emergency. Here's how much we think it would cost for us to be able to trust this. And that would be a source of more like nimble, responsive funding. That would require, I think, a statutory change, but we would want to explore that with the relevant stakeholders or something similar. I think Catherine and Duan raised their hand at the exact same time. So I don't know, maybe Duan wants to clarify something I said.
I do, but why don't you, Catherine, you go first?
I don't know. I was gonna ask a clarifying question because I thought there was an effort to change the statute, which maybe I gather now wasn't successful.
No, that's exactly I wanted to clarify. So we last year we did advance a revision to Business and Professions Code 6033. This is what Chris is mentioning. This is what we call our voluntary contributions. So in the State Bar licensing fee, there's I believe a $45 opt-out that right now by statute says it needs to get rolled into IOLTA grants, and it goes out for formula. So we explored revising that part of the statute so that the commission can have discretion to fund what we're calling urgent and emerging kind of needs, such as like disaster. And in this context of this year, like if a program receives like funding, like a sudden funding loss, maybe we could backfill that program for a little bit or be kind of bridge funding. So it would kind of change every several years. Last year, it didn't go through. We are still now in conversation, so that legislation is actually still alive. We're very hopeful will be passed. But there's another half of this piece of legislation. So there's a funding piece, and then like the second paragraph of it is for the commission to actually have a task force or work with the legal services community to kind of explore whether the voluntary contribution should go out a certain way and what we can do to be more impactful. So whether that changes or not, I think we need to like still do that. And it says it needs to be done. I think it's like every 5 years, like every 2 years was like optional every 5 years. So we actually are due to be doing it this year. So one of the things that we are proposing is like that task force, or however we want to determine it, will go through the PDI committee so that we can get a little bit more feedback with the community. I think this is, I mean, it's a statutory requirement, but it is a really great opportunity to really figure out what are the needs in the community, how our use of IOLTA, we've been distributing IOLTA funding through the formula for 40 years. There hasn't been a lot of modifications. Is this kind of the right way to be distributing IOLTA, right? This voluntary is kind of a little bit of a test case. It's a portion of it, a smaller portion of it. But I think there should be probably a lot more analysis and feedback with the IOLTA community, other policymakers. We engage the Access Commission, we engage Judicial Council, LAC. So there's a lot of opportunity there. But yeah, I did want to make that clarifying point that 6033 is alive, and this is where that's coming from.
So I just wanted to raise sort of a corollary like thing I worry about. So there are, I'm going to get the number wrong, but a dozen-ish LSC programs and some other big programs that get a lot of federal funding. And I think, like I know for my former program, they've been zeroed out for most of their funding requests. And so for this next year, the formula will be based on this year's expenditures, but there will be a year in which the impact of those funding cuts will be significant and mean that the amounts that are qualified by these very large programs change dramatically. And I have no idea what to do about that, but I think there's like a year or maybe 2 years for LSC, which budgets a year before, to actually, I mean, to me, it's one of the most important things if the commission wants to be proactive is to begin to think about this. What do you do when programs who have been providing them, if you look at the numbers, like what numbers are generated with the funds that are provided, and those funds go away and now they get a much smaller IOLTA grant. What is the impact on the legal aid landscape in California, and how are we going to think and talk about that, which I think should happen this next year, honestly, like soon.
Well, I think that's exactly the type of discussion. And then layered onto that, because I was just emailing back and forth with Selena, like we're at 120 organizations now, right? So in the span of, 4 or 5 years, we've had a 20% increase in terms of grantees, right? I can't remember the dollar amounts. So we need to kind of do all that analysis and then figure out kind of the impact. So there's LSC, right? 11 programs right now. What's on the table is a 15% cut for LSC that we've been told is probably not going to be deeper than that. But when at the conference that we went to last week, there was very good questions from non-LSC programs that were like, are you doing scenario planning in the event that the cuts are deeper than 15%? And that's just LSC, right? We know with a lot of our programs, right? Because the vast majority of our programs are not LSC funding. They're getting dramatic funding cuts already at the local level. We've heard anecdotally, I think I reported some programs that have already started to do layoffs, eliminate program. And then you saw on one of the slides that Heidi reported earlier, I believe it's 4 tranches of our funding is just, it's gone, right? There's no more homelessness prevention funding. There's going to be no more consumer debt funding. Our bank grant funding is going. So our office, we're doing kind of research in terms of other revenues, but I do think you're right, Catherine, coupled with that, we need to do a little bit more of a full analysis on what's happening. And it's very hard though, but I think there needs to be probably some attempt and then some strategy. So I think this is where I was hoping the conversation would go in terms of like that high level strategy, like what else the commission can be doing, gather that information and to kind of help, right, further along in terms of coordination and but that feedback, Catherine, is very helpful.
I mean, and I think like if you say what is the future of legal aid in California, and you played out sort of the worst case scenarios, it is this really significant drop, in federal resources combined with IOLTA rates simultaneously going down. And so that the amount of money to serve now this very large group of individuals could be, I don't know, a third of what it is today. And what are we gonna do about that? I mean, it's just like, we have to step back and sort of like, I don't know that it's, I mean, we will know October 1st, I think, roughly.
Yeah.
By then, what the federal budget landscape and what is the total loss of revenue. And Heidi and her team seem quite skilled at keeping track of what's going to happen with reductions in interest rates and what does that mean. And the combination of those two, I think, can be absolutely devastating to legal services to poor people. Not to end on a bad note.
An important one. Any other though thoughts on this? Because yeah, Selena.
I mean, just to kind of wrap up several themes, as I mentioned earlier in my liaison report, there's just so much uncertainty for our community. And right now, the strongest thing that we can do is talk with each other and work with each other. And I think I may have reported recently that many organizations are talking about efficiencies on the back end, potentially merging some of the programs or projects, and really figuring out how, in a time of limited resources, to not have to compete for those scarce resources. So we've been encouraging organizations to approach local, city and county, leaders for joint applications. And so that's really what we're hoping to do, is that we don't spend a lot of time and effort to compete with each other, that we really work together. And the second column that Chris has here around Cypre, there's a lot of effort and work that we can put here in order to ensure that we're getting funds for legal aid that not necessarily in competition with others, because a lot of it is just educating judges and counsel about the availability of Cypre and making sure it doesn't go to law schools or something else.
Thank you for providing that segue. Everyone's giving me my segues because I wanted to pull in Cypre. So I see two hands shot up, but let me just say to frame the Cypre piece. This is something that there was an extremely thoughtful session on at EJC. Selena actually was one of the presenters on it. So Selena, please jump in again. There is, in California in particular, a lot of potential funds for civil legal aid that could be the result of Cypre settlements, residual funds from class action lawsuits. For those who are a little unsure what that is, when a civil action settles, sometimes the parties can agree that funding that didn't end up going out to the class members can actually go out for a different public interest cause. And legal aid is nearly always, if not always, an appropriate recipient of those dollars. So the amount of funding available in any given year is always in flux. But legal aid's ability to tap into it and this commission's ability to leverage it hinges a lot on strategy. Like how many sort of like litigants in the state and their attorneys and judges and courts know that the commission can administer Cypre funds very effectively and strategically, and that legal aid is a fantastic recipient of those dollars, is like a public awareness and education campaign. So I'm sorry, I kind of cut in front of Dwan and Kenneth, but Dwan, I think you had raised your hand first.
Yeah, I just wanted to kind of bring up kind of a positive note about our community, because last week we hosted the IOLTA programs, like our national. So we had in our office, I believe it was like 40 or 50 people from 20 states. And we were so pleased to report, like in California, there is so much collaboration despite what's happening, or I guess in spite of what's happening, like at the local level, in terms of like in LA, there's so much coordination that other states are just, it's not happening, even though we're a large state. So I think there are some things that we can capture there about that sense of coordination and collaboration, support of one another, that feels like really positive in this kind of moment in time. And then on the Cypre funding, what I'll say to add to this is, you know, we haven't done a lot to be strategic in Cypre funding. We don't budget for this. And, you know, this is very hard to budget because it's unpredictable. And I have to say, like, you know, for a long time, the Cypre funding was really variable. Some years we get like 200,000. Some years we get 500,000. The last few years, though, we've gotten like in the millions. And I don't know if this is a direct correlation, but there used to be a judge that sat on this commission, Judge Seligman, who was a big proponent of Cypre and did like judicial kind of education. And I don't know if he's still doing it, but I want to think that there might be some connection there between his like ability, his what he was doing judicial, and then now that we're getting Cypre funding. I don't know if that's exactly, but I do think that there's like a lot of opportunity here for us to kind of like figure out Cypre funding, if there's a larger strategy, if there might be like a court rule change, like in another state that Selena and I are talking to, like there's like a notice requirement that they have to notify like the IOLTA program when there's a Cypre funding, so that we have a shot at like saying, hey, you know, direct the money to us. So I think there's just a lot of opportunity here, and also like a communications thing. One thing, and I'll embarrassingly share with you, that Chris and I sat in this meeting and we're like, we don't do this, is we get a Cypre award and we don't actually send a formal thank you letter. So now we're going to do that, right? And we are thinking of either having me call or maybe the chair of the commission call. I mean, we just got a $3.5 million check. And yes, I did informally write and say thank you, but we need to send out something. So it's just, again, a lot of opportunity here that I think we should explore as a commission.
Duan, is it fair to say that this could actually go hand in hand with what we're calling the quote task force for the 6033?
I think so.
This can kind of go, because they're both potential opportunities for the commission to be able to fund emergent and urgent needs more nimbly. There's the attorney donations, and then there's Cypre, they're different, but it's like they could be leveraged in the same way.
I think so. I mean, that's why we want to get a sense from all of you, because there's a lot of things, right? So as I'm listening to all, I think we can put probably a lot of things together, like maybe the listening session is part of the task force to get a little bit more information. We can work with LAC. They're already like you know, so we can try to put together some of these themes. So again, we're not overwhelming our grantees, we're asking them for so much data, so much survey. So we have to figure out a way that's like, we don't want to create more work, right? That's tenable for them so that we can help support and get the information that we need. But I do have, like, as I'm listening to you all, some ideas.
You've been so patient, Ken. Thank you.
So the Access to Justice Commission's funding committee that Catherine and Selena and Duan and I regularly attend the meetings of has looked at the Cypre issue off and on over the years. It has been a while since the funding committee of the commission, the Access to Justice Commission, has looked in depth at the Cypre issue, but we did find some success with the idea of judicial education. I think that the idea of judicial education is an important way that this commission, working again with LAC, working with the Access to Justice Commission, could help get the word out about Cypre. I also think working with the consumer attorneys of California to get the word through their membership would be a helpful way. I mean, in my experience, and I received a fair number of Cypre awards when I was the executive director of a grantee. They typically came to me through relationships either of defense counsel who perhaps were on my board or whose partners were on my board, or through plaintiffs counsel who somehow had heard of the work that we did. And I think it's probably harder to work the defense side of it, because you're largely dealing with big law, and you're dealing with big law who has relationships with individual programs. And so there's not really a great way other than through perhaps the Association of Business Trial Lawyers, ABTL, to get the word out to that side of the defense bar that deals with large class action settlements. But on the plaintiff side, CAOC is the way to get that word out. And I would think by education and information through CAOC and through judicial training, we could greatly expand the pool of people who are thinking about the state bar as a place for Cypre. And it's actually not just, it's codified. It's in the CCP that the state bar, that the IOLTA program or Trust Fund Commission is a eligible grant recipient for Cypre distributions.
So, I mean, this might be the time where, like, it's LAC, the Access Commission, the Trust Fund Commission, we can kind of put our brains together and collaborate. And Ken, you sitting on both the commission and that funding committee might be a good kind of segue for us to do some of this. You know, we had this toolkit that I think a few years ago, Catherine and I had thought about resurrecting, so this is probably the time to do it.
Erica.
Actually, before I speak, Judge Klein, are you raising your hand? Did you want to say something?
Yes.
Go ahead, you can go first.
It's been a long time since I was in district attorney's office, but we had set up a real estate fraud task force, which a number of legal agencies, I know PetCedec was on, a public counsel, to participate in activities. I think the city attorney at the time seemed to be doing that a lot. I don't know the current status, but there are government agencies that did work together.
Thank you, Judge Klein. Erica?
Yeah, I was going to echo that too, that there's, I think looking at government agencies that do, you know, some of their especially on the civil prosecution side, some of the penalties are kind of statutorily defined how they go, but there's sometimes like restitution, those kinds of things. So it might be worth partnering with the agencies as well, because if there's like a particular wrongdoer, you know, funds that can go to fund a grant or something like that, even if it's not strictly Cypre, right? Like might be a way you could partner with them. I know like our agency administers certain grants that we get that are part of settlements that we've reached. So something to think about. The other thing I was going to say, Ken, to kind of your point is like, I know that we're thinking about going on these listening sessions with grantees, but I also kind of wonder or want to suggest whether we deploy the commissioners into these sort of listening / outreach sessions with various contacts, you know, to like the plaintiff sidebar, like, you know, the plaintiffs associations, or start having that, like using our network and having people talk it up. And this is where like staff, what might be useful is having like a one pager, right? That a commissioner could like grab and be like, okay, I understand how Cypre works. This is the statute that says it's like appropriate. Okay, you know, who can meet with whom, and like go out and just like help educate them. So just something to think about. I think a lot of people, you know, on the commission have some of those relationships, and it might be useful to use us in that way. And also to use our alumni, right? Judge Seligman is an alum. He might be someone we should reach out to and have some conversations about the best ways to approach, you know, folks on the bench so that they're aware this is like an option. So just some suggestions.
Thank you, Erica. And we can keep thinking about Cypre and 6033 attorneys donations, but I wanted to bring in at least one more topic before we close out. And I think maybe the hope is to let you go a little early if that's possible. So I wanted to also flag our training and technical assistance initiative. I described it a little bit earlier. It's currently prioritized. I want to get your feedback, your ideas for like other things we should consider prioritizing. Currently, it emphasizes sort of proactive knowledge and skills to manage legal services trust fund commission awards to their full potential, to be able to comply with whatever the authorizing statutes requirements are, state bar regulations, increase efficiencies, strategy to facilitate peer support between grantees who got the same funds. And it has sort of emphasized, and I kind of gave you some ideas earlier, like how do you manage federal funds if you got a federally funded grant and the like. So I wanted to just give you a sense of like what some of the upcoming things are, and then ask you if you have other ideas of things we should consider prioritizing or different kinds of strategies. And the more that something I've observed as this initiative has developed is a greater appetite for peer support between the programs, that the programs really like hearing from each other on what the strategies they're trying to reach particular communities, and then they sort of will share like the challenges they each face and how they're overcoming them. And so it's kind of like leveraging their expertise has been really popular. So a couple of the things that we have coming up, these have just been proposed. Some are a little bit more in the works than others. We are exploring how to support grantees that focus on delivering veterans legal services. We're exploring trainings or panels or roundtables at the intersection of legal technology like generative AI and disaster legal services. We're going to be looking at how to get help the grantees to sort of leverage the information that's going to be coming out of the Justice Gap study that's about to be published. And then a lot of stuff around IOLTA and EAF budgeting, which happens over the summer and fall. And there's other things too, but I just wanted to stop there and see what are your thoughts of topics and strategies to prioritize in the way of convenings and roundtables and workshops and the like, or anything that you've heard you want to know more about. We'll say one more thing while you're all thinking, which is we did do a survey last summer of what the grantees at the time were most interested topically for future trainings. And the two things that kind of came up the most by far were fiscal topics. So we did just actually do one. Heidi just led a training in our senior fiscal analyst Esteban led a training on how to navigate fee generating work when you also have IOLTA and EAF funds as a way to sort of make sure you're financially resilient, and how to design competitive proposals. We are seeing, like, as you saw, some of the competitive grants are going away. Hopefully they will come back in some form, but like they are going away. So that might be actually something that grantees are a little less interested in now, but a year ago that was one. So we have that on our list too. Great, Erica?
So I'm not sure this is about technology, but this sort of swings back to something I was talking about earlier, which on the rules committee stuff is I wonder whether sometimes as we deploy new rules, we should do like little maybe we already do this, but like kind of webinars or education where we can kind of talk grantees through what the rules now require and how they can comply and, see if they have any questions. I don't know. I'm not sure if that's in line with what you're talking about as far as the technology issue and TA, but just wanted to flag that because I think that might be helpful, especially we have one that's coming out that's all about like quality controls and financial controls. And so that one might be useful to like, have a discussion with the organizations about what is and is not required under that. So just something to think about.
That's great. Thank you, Erica. Someone's hand went up just for like a brief second and I didn't see who it was, but if
it was me, it was an accident.
Okay, that's great. You almost had the last word if you wanted it, but this is also a great place to end because this was an extremely helpful discussion. So unless anyone has any burning last thoughts, I can yield the rest of my time, which is like only 15 minutes, but.
Well, this is great. Thank you all for the very helpful discussion. I thought this was like really, really interesting. And so appreciate everyone talking through some of these. And thank you to staff for bringing these topics to us with, some really interesting ideas. And it's helpful to kind of like, I think, give us like some examples of what you're thinking, because I think that really helped get conversation flowing. With that, I know it's only 15 minutes, but let's wrap it up slightly early. I just want to remind everyone that our next meeting is August 8th, and it's going to be hybrid. So for folks who would like to and are available to, there will be in-person options in San Francisco and Los Angeles. If those are not feasible, you can also still do Zoom. But just wanted to say, if you're in one of those two locations and would like to come be in person, I'll probably be making the trek out to San Francisco myself. Otherwise, thank you so much. What a great meeting today. I appreciate everyone's really helpful feedback. And again, a reminder, Board of Trustees tomorrow or Friday morning, if you want to come and, watch. And if you really want to make public comment and support, feel free to do that. I can't stop you, and I would encourage you, but no pressure, but also happy to have anyone who wants to come support. Otherwise, we'll report back. Thank you all. Have a great rest of your week.
Thank you. Bye-bye.
Thank you.
Thanks all.
Bye.
Bye.